Good morning. Welcome to today's court enforcement hearing. My name is Myrna Roche. I'm going to be your magistrate today. This is a quasi-judicial hearing, which means it's like court, but the rules are less formal. Everybody that is here on behalf of a case will have an opportunity to be heard. I'll ask for, as the cases are called, if you're here for a particular case, go on that side of the podium. Mike's working today, right? And we'll have the city, the town on this side. This time, I will ask for those who are going to be providing testimony to please stand up for the taking of the oath. You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth. With that, I will ask the town to please call the first case.
Madam Magistrate, the first case, can you hear me? The first case this morning is going to be from our Beach and Street Patrol. It's going to be, the citation was issued to Robert Adams. Presenting the case is going to be Kevin Shevashevsky.
That 3 times fast.
Mr. Shevashevsky, could you please state your full name for the record?
Evan Michael Shevashevsky.
Are you employed by the town of Fort Myers Beach?
Yes, sir.
What capacity?
A base patrol officer.
In that capacity, are you responsible for enforcing the town's parking regulations?
Yes, sir.
Are you familiar with the citation that was issued in case 703-26443?
Yes, sir.
Can you please tell the special magistrate the circumstances regarding the issuance of that citation?
While patrolling that day, I observed that vehicle parked in space number 6. Yes, space number 7. When I observed it, I checked my phone, the way we checked it, what's paid and what's not paid. It was unpaid. I issued a summons.
Did the town send out a notice to the property owner regarding today's hearing?
Yes, sir.
Did the vehicle owner, ask for a hearing today?
Yes, sir.
What is the fine that the town is seeking in this case?
Fine itself is $35.
And any associated
Administrative fee would be $175.
nothing further?
Okay, do we have somebody here on behalf of the vehicle owner? Okay, and as such, there's nobody here on behalf of the vehicle owner. What is the town requesting?
Sorry?
What is the town requesting? $35 fine?
The fine of $35 and an administrative fee of $150.
I hereby find that the violation as stated in the citation did exist, and as such, I'm imposing the one-time fine of $35 and the requested admin fee of $150.
Within 30 days?
Yeah, but within 30 days.
Madam Magistrate, number 2 on our agenda is going to be regarding Belle Susan. This is going to be presented by Officer Kevin as well. However, it was issued by an employee who is no longer here.
Okay.
Officer, again, please state your name for the record.
Kevin Michael Shevashevsky.
And you've already testified that you are employed by the town of Fort Myers Beach
Yes, sir.
as a base officer, as I believe.
Yes, sir.
In that capacity, are you responsible for enforcing the town's parking regulations?
Yes, sir.
Are you familiar with the citation in this particular case, 709-53212?
Yes, sir.
Please tell the special magistrate how you're so familiar.
Okay, when I observed, when I reviewed the case, I observed the pictures that were taken by the officer and the vehicles parked blocking, not in a legal space. All our legal spaces are marked with a sign. And this particular vehicle is blocking the egress and ingress of a walkway of Newton Park.
And the photographs in the file accurately reflect the condition on the date that they were taken?
Yes, sir.
Did the town have an occasion to issue notice to Ms. Bell of this citation?
Yes, sir.
Did Ms. Bell request a hearing today?
Yes, sir.
Further? Oh, I'm sorry. The fine that the town is seeking, officer?
$50 fine and $175 administration fee.
With that, it looks we have somebody here on behalf of the vehicle owner. Please state your name and relationship to the case, please. Okay.
Was ampler walkway. Also, if you look down from there, that wasn't the chief complaint at the time. It was that there was an unmarked parking space. There is room to have a no parking. Look to the left of the driver's side door. There is a sign that is a parking. So to the best parking spot.
Challenging. We did observe two other walkways, one down by the handicap and one that is designated parking area. And for us, yeah, they look the same.
Just for the purposes of the record, I know they don't have him up on the podium, but I do have pictures with the layout. I don't know, they should, those pictures shown to the
I
vehicle
don't know,
owners?
but if they want to, they can certainly take a look at them if they wish.
I want to make sure that they're able to see. Go ahead and see what I'm looking at.
Walking the walkway.
Magistrate,
I understand the pictures, yeah.
Yeah,
These are not the same cars.
The issue is not that there are other walkways. The issue is that they were parking in a space that, or they weren't, they
Was a
parked
designated.
in a non-legal space, and in the process, blocking that particular walkway, not the other ones.
I was going to say, it almost goes the other way. The reason that there's no parking space there is because there's a walkway there. There's a reason for the design.
Not challenging what is illegal. We're challenging the
Designated.
simple public know that that's not the. Too ambiguous. Much ambiguity around that.
There needs driver's side door, there is.
And I'm looking at the aerial, and there seems to be like a divot in the way that it's done. Probably with the intent of that area being left open. I didn't design it, so I don't know what the intent of it was. All right, I'm ready to issue my ruling. I hereby find that the violation as stated in the citation did exist. I'm imposing the one-time fine of $50, but I'm gonna go ahead and reduce the admin to $25.
It wasn't,
30 days, yeah.
Madam Magistrate, next we move on to the imposition of lien cases to be heard. We're going to move to number 3. Property owner is going to be Wilfredo Rodriguez. This is case number CE 19-100-010. I'm sorry, 0110. Presenting this case is going to be Code Officer, our short-term rental coordinator, and Code Officer Kristen Schumacher.
Ms. Schumacher, can you please state your full name for the record?
Kristen Schumacher.
Are you employed by the town of Fort Myers Beach?
Yes.
In what capacity?
Term rental coordinator.
And as the town's short-term rental coordinator, are you familiar with this particular case?
Yes.
CE 19-01110. Can you please, was there a previous hearing in this case regarding the underlying violation?
Yes, November 21st, 2019.
And was, to the best of your knowledge, was the property owner found to be in violation of the code?
Yes.
And what was the time period in which the property owner was given to come into compliance?
They were given till December 31st, 2019 to come into.
And as of this date, are they in compliance with the special magistrate's order?
As of this date, yes, but during this time period, no.
Okay. So how many days was the property owner in non-compliance with the special magistrate's order?
This was between January 1st and September 17th. They had 25 stays, which resulted in 15 violations.
And the total amount of that accrued fine is?
Total amount is $4,075, and this was the magistrate's order per occurrence.
Is the town asking for a particular monetary amount in the form of a lien at this point in time?
Madam Magistrate, the 15 occurrences that you ordered were at $250, which equals $3,750. You also entered a one-time fine, or ordered a one-time fine of $250 plus a $75 admin cost. The total of all of that is $4,075. So you have 15 violations at 250 equals 3,750, plus the one-time fine of 325 and $75 is $4,075.
Okay.
Which is what the town is asking for.
But it is in compliance, so it's not going to accrue anymore, as far as the testimony from the town.
Up to today.
Okay.
Yes.
In regards to this case. Can I hear from the respondent, please?
Yes, Your Honor.
Your name?
Fredo Rodriguez.
Okay.
For this case, I've been here, this is already, I think, my 5th time.
Yes, remember you.
Because of COVID and whatnot, the initial time, my fault of my own, because I was the very, very last one here after there was an attorney in a case for about 4 hours. I just accepted whatever was thrown at me. I just wanted to go home, everybody wanted to go home, and I just said yes to whatever it was. That's my fault. But since then, I've been here another 3 or 4 times for the same case, where these things have still been accruing. Had this been closed way back when, I wouldn't have the 15 violations. It would have been closed off already.
Why would it have been, the 15 violations wouldn't exist? My order said stop doing the short-term rental by December 31st, and you didn't.
Well, I didn't have that many. I'm not sure where the 15 came from, but I haven't had that many. I know for a fact I haven't had 15 violations. I only had one case number. I had one violation, one case number.
I understand though you had the violation with the case number, but you kept renting it afterwards.
I don't know if it's been 15 times, because right after that, I switched my calendars for Airbnb and VRBO. So I know I had violations. 15? No, not 15. I know that I reset my calendar and I fixed everything after we had that discussion. This case keeps on getting reset and prolonged and postponed, and I keep on coming here to, I would pay the fine and get it done with.
You wouldn't be here if you had not rented it pursuant to my order past the December 31st deadline.
No, it's the same case. It never closed out for some reason.
I know, because I said until December 31st.
Right.
You
But
would have followed my order that you were not supposed to do short-term rentals after that, because I gave you more than a 30-day period to purge them out. Because we've been doing this, we have been very consistent about the orders on these type of cases. 30 days out to purge when it's the first time, I understand, maybe they didn't know, but after those 30 days, it's your responsibility to go ahead and purge the rest of them out, and you didn't.
I didn't have 15 violations. Sure.
But you're not contesting the fact that you did it, you're just contesting how many times.
It's been so long, I couldn't even tell you what. I mean, I know that I didn't have 15 violations, I didn't have 15 issues, and I know that that same day.
15 violations, you had 15 additional short-term rentals, despite there being an order, me telling you, don't do it.
Oh, correct. But no, I haven't had 15,
Well, how many have you had?
I couldn't tell you. Because, I mean, I know that it's been rented, but I'm not sure what the city is using as proof that it's been rented shorter than that. I mean, I've had it rented for 7 days.
The material's in the file.
Yeah.
So we provided to you each and every instance of the 15 rentals in violation of your order.
I haven't seen those.
Well,
have 'em.
more than willing to come over and, at any time and meet with staff to review that material. We'll provide a copy with you today, but that's, our evidence shows 15 violations, Mr. Rodriguez.
Yeah, because I mean,
It's very simple. You either comply with the special magistrate's order, or the city, or the town is going to continue to bring cases before the special magistrate.
I did purge my calendar. I purged my calendar. Then we had the whole COVID thing where everything got reset.
It's your responsibility.
I understand.
In the meantime, whoever it was, there's evidence that we have showing 15 rentals.
How
It's
do I
in the
see
file.
Ms. Callen. From reviews. So you're Madam Magistrate, and you have the reviews?
it. I'm looking at
Yes.
them.
Okay.
I have that same package.
Yes.
The reality is, Madam Special Magistrate, we wouldn't be making the allegations and the request at this point if we didn't believe we had
yeah.
documentation to support it.
Why not? And he has admitted that he was doing it. He hasn't denied it. He's contesting is the
Just the number.
15th, but no idea how.
Last year, so it's hard to even remember what's been going on. It's 2019.
We've been able to document it.
Yeah, I'm comfortable with what I'm seeing, that I can substantiate the 15. If you have evidence otherwise, again, you can meet with the city and check and see their record, and if you find something otherwise, then you can go ahead and take it over to the town council and appeal it at that point in time. But right now, you have an I don't know, and I have documents supporting the 15. I have to go with what the evidence shows. All right, I hereby find that the magistrate's order, where's my order? I hereby find that the magistrate's order dated February 6 of 2020 in relation to the hearing of November 21st, 2019 was not complied with, and that the one-time fine of $325 that was originally ordered was not paid. Since that order, 15 additional short-term rentals have taken place based on the evidence presented by the city, and as such, I am certifying liens, fines in the amount, fines and the admin cost totaling $4,075. And by certifying this amount, it'll become a lien and it'll be recorded in the official records of Lee County, Florida.
Your Honor,
Yeah.
the initial fine and fees, I paid for that same day.
Okay, go ahead and
Okay.
give that over to them. If they have to bring it back to me to go ahead and amend the amount, that's not a problem. I mean, right now, I certified it, but like I said,
didn't see that,
they
but-
go ahead and take a look at these items, show proof of that, and if we have to revise it, we'll revise it.
He can prove
Or
it,
thall go
then
ahead and do a
yes. I
partial
mean, but
satisfaction.
That's not what I saw. That's all I'm saying.
There's many ways to address it,
Let's just have a conversation.
Yeah.
but it's gonna be your burden to go ahead and.
If Mr. Rodriguez can provide us with that evidence, we'll request an adjustment to the.
We can do either a
Yes.
partial release, or we can do an amended lien, or there are many things that can be done.
Okay.
But I don't wanna hold up the rest of the people going ahead and.
All right, Madam Magistrate, next is going to be Mr. Rodriguez again.
Okay.
Case number CE 19-0520. This is also an imposition of lien regarding daily rentals in a weekly rental zone. Code Officer, Short-Term Rental Coordinator Kristen Schumacher is presenting the case.
Schumacher, you've been previously sworn, correct?
Yes,
And you are employed by the town of Fort Myers Beach
yes,
as the town short-term rental coordinator.
yes,
In that capacity, are you familiar with KCE 190520?
yes.
Will you please tell the special magistrate how you are familiar with the case?
I did research. I originally received complaints and brought this case to hearing on November 21st, 2019. Was ordered to cease rentals by December 31st, 2019. And by May, was it renting for less than a week from May through September 19th, 2020. I found 16 violations of rentals for less than 1 week.
Are those rentals in violation of the special magistrate's order?
Yes,
And are the evidence of those rentals in the file?
yes.
What is the total amount of the fine that and fees that have accrued as a result of non-compliance in this case?
16 violations times 250 per occurrence is $4,000. And we're double checking to see if it is fines originally ordered.
For the record, Special Magistrate, the previous case that we heard just a moment ago involving the same property owner was for property located at 5765 Lauder Street, whereas this one is for property located at 215 Nature View Court.
Understood?
And he did pay his $5 for both cases.
Did? Okay, so we gotta go ahead and
Amend the previous
amend the, okay, so go ahead and do it really quickly on that prior, I'm gonna call back the prior case, CE 19-0010, that the amount that I certified is hereby reduced by the $325 that he already paid. The remainder of my order remains. Okay, so now we have,
So in this particular would be the 16 times $250, $4,000 plus the admin.
No, that was paid as well.
That was paid as well, so it's just $4,000.
1,000, yeah, I removed the 325 from both, okay. All right, and we have some, Mr. Rodriguez is here on behalf of himself as the property owner. Are you provided with the documents?
This one, no. But I'm looking at the past one where it shows my truck on the driveway. I'm being violated for staying on my own property.
So basically, it's the same thing as with the other property? Minutes to go ahead and review the document.
Your truck, no?
Right.
Wait.
What I'm-
Truck's there. So, for
Ever possible.
empty. They're back again after. A couple days later. There for a couple days. Minimum days?
It would have been.
They're there for 3 minimum days?
No,
Minimum 7.
so that's,
Yeah.
so I'm not getting validated for those days, right?
No,
522, 523 is right here.
you check in, right?
No, that's me right there.
But do they check in on the 22nd? Well, then you're telling me they're there for less days, so the 23rd and 24th gone, and you're back.
Very thorough.
I was there the 24th, so that's Memorial Day weekend, that's my birthday. I was there the 24th.
Mr. Rodriguez is misunderstanding the photographs of his vehicle. That's to show that in between those dates, there were other rentals.
I just want to
We're
give
not
him the
disagreeing that
opportunity
he was
to,
there on those days.
I just want to give him the opportunity to review the evidence upon which the town is accounting for those 16 times.
I feel like I even have in there. If
If you have evidence otherwise.
725
He's the
to 82,
intervening
no
cause for
violation.
the,
Like, I look to see where your car is. When it comes back, after it, you have a trend, after every rental, your car shows up for a day and then goes back to Miami.
This weekend, I was there this weekend. It wasn't Memorial Day weekend, it was McGriff. I was there that weekend. I'll tell you that much. I cannot account for any of these days because it's been a year.
Right.
I can tell you that weekend I was there. That's why my truck is there on the 22nd, and that's why it's there on the 20th.
You also have 2 units, right?
Houses, I rent it as a whole.
Oh.
I don't rent it 2 units.
All right, Mr. Rodriguez, I'm ready to go ahead and issue my order certifying. Again, if you have evidence, just as with the other one, if you have evidence showing otherwise, I invite you to go ahead and either take it back to the town council, or I'm sure if you talk to the town, they might be amenable to go ahead and reducing it. But right now, there seems to be sufficient evidence that my order was not complied with. And as such, I will be entering my order. I hereby find that the magistrate's order dated February 6th of 2020 in regards to the hearing that took place on November 21st of 2019 was not complied with. And during that time period, there were 16 additional rentals that took place thereafter. And as such, at the rate of $250 each, fines have accrued to the amount of $4,000. I hereby certify the order in the amount of $4,000 because he paid the $325, and by certifying said amount, shall become a lien against the property to be recorded in the official records of Lee County, Florida. Next one.
Your Honor, number 5 on the agenda we have closed, so we move to number 6. Number 6 is going to be Mr. Stephen Tarr. This is case number 2019-0604, work without permit, Canopy Boathouse. It's going to be presented by Code Officer Steve Wick.
I got one. Mr. Wick, can you please state your full name for the record?
Stephen Lee Wick.
Sworn in?
I have.
Okay. Are you employed by the town of Fort Myers Beach?
That is correct.
In what capacity, please?
I'm the floodplain administrator.
Are you familiar with the case that's referenced 2019-0604 for the property at 521 Madeira Road?
I am.
Tell the special magistrate how you're familiar. I believe that this is a lien certification, so there was a previous order of violation entered in this case. What has happened since that, the issuance of that order?
That order was issued on the 20th of August, 2020. I received an email with a photograph showing that the canopies had been removed. This email was received on 10/30 of 2020. However, on 10/16 of that month, the canopies were still in place, so sometime in between those two dates, the canopies were seemingly removed, and it appears that there is compliance in the matter, at least as it regards to the presence of the canopies. They're no longer, they were there for an unspecified number of days after the order.
And are those calculated as approximately 30 days?
The order was 30 days, yes.
Given, well,
I'm sorry, from,
oh, never mind.
how long were the canopies up in violation of the special magistrate's order?
I used the original date of the email that I received because that was the first evidence that I had that the canopies had been completely removed. That would have been, again, 10/30/2020. So 41 days had elapsed since the order. The fine was $250 a day. Comes out to $10,250. Plus there was an original fine that's not added into that amount of money.
And was there an admin fee also assessed?
Yes, a $75 admin fee, and the original fine was $250.
Or any of these, were the original fine and the admin fee ever paid?
I don't believe so. Mr. Tarr I think came in early this week to pay the fines and wasn't able to get into the building to do so.
So is the total outstanding lien that's being requested by the town $10,575?
Yes, I believe so.
Further.
All right, state your name and relationship to the case, please.
Sarah Spector, I'm an attorney with Retzel and Andrus. I'm here on behalf of Stephen and Gabrielle Tarr. They're the owners of 21521 Madeira Road. Tarrs are Canadian residents who, shortly after purchasing the Madeira Road property, entered into a contract with Hickox Brothers to replace the docks adjacent to the home. The contract executed by the Tarrs indicates that 2 canopies would be installed over the main dock and the accessory dock. The contract also required Hickox Brothers to obtain all necessary permits. Hickox performed the work, even replacing the canopies in their entirety at significant additional costs as a result of damage from a storm. However, there were 2 flaws that later resulted in code enforcement violations. First, the accessory dock was built so that it encroached upon the neighbor's property, as Hickox did not properly locate the construction area. Second, though the DEP permit was amended to include the canopies, neither the initial nor the amended application submitted to the town included the canopy. Tarrs, who had entrusted Hickox to perform the work as set forth in the contract, and required by all local and state regulations, again turned to Hickox to address both situations. That did not result in abatement of the violations. Tarrs hired attorney Michael Cayusa to assist, and Mr. Cayusa is here today. Again, the Tarrs put their trust in Cayusa to close out the code enforcement matters, which became vitally important in March of this year when the Tarrs had to return to Canada before the U.S.-Canadian border was closed. Starting in October of 2019, Cayusa put pressure on Hickox to abate the violations. Tarrs were led to believe that all violations were abated when the town issued a certificate of compliance for the dock on July 17th, 2020, before the hearing on this matter. I had no idea that the CC did not cover the canopies and that the permit never included them. Because they could not leave Canada as a result of the border closure, we're not receiving any notifications from the town relative to hearings. This was the case even though the Tarrs, in conversations with Code Enforcement Officer Eli Lee, mentioned they were in Canada and asked that all communications also be sent by email, since certified mail is not forwarded. Even though the special magistrate orders were issued on September 2nd, the Tarrs, who were still in Canada, were not made aware of the code violations that they remained outstanding and fines had begun to accrue until a neighbor advised them in October that the orders had been taped to their garage door. It was not until the Tarrs engaged the services of our firm in mid-October that they were made aware of the fact that the permits did not include the canopies. In question, Hickox insisted that the town did not require permits for canopies and refused to obtain an after-the-fact permit. The canopy on the large dock was damaged by a storm and removed on September 23rd. We do have a flash drive here from the Tarrs ring camera that shows that the canopy was in fact removed on the 23rd. I also have affidavits from Hickox and Mr. Cayusa that confirm that the accessory canopy and all remaining canopy structures were removed on October 30th, as soon as the Tarrs were made aware of the running fine and lack of permits. I have those to enter into the record as well. And I forgot to mention, I do have an affidavit from Hickox relative to the September 23rd removal of the large canopy. We're here to ask today that you consider reducing the fine due to this unfortunate series of events. TARS paid for the canopies and their installation twice, both times believing Hickox had attained the necessary permits. They've hired 3 professional firms to assist with this project. Their ability to participate in the process or even receive notice of it was severely impacted by the COVID pandemic. There was no life safety issue presented by the code violation. Abatement was removal, and the TARS removed the canopy structures as soon as they learned of the code violation. That the code violation remained, that the fines were running. They will not replace either canopy until they have secured the proper permit by using a different contractor. Based on the foregoing, I should first mention that it was mentioned that that Mr. Tar did try to pay the initial fine and the admin fee. Earlier this week, we did try to pay again today, and he was not allowed to pay again today. We do want to pay that amount and have been trying to pay that amount, but we would ask that you reduce the remaining fines that ran from the date of your order requiring compliance to 0.
All right, anything further from either side?
Yes, Your Honor, or Special Magistrate, we would just simply point out that while we're not necessarily disputing the statements of Ms. Spector as to the issues that the property owner had with regards to the contractor and who may be, who's at fault for the underlying violation. At this point in time, the only issue for the Special Magistrate to consider is, was your order complied within the time specified, and if not, how many days it was in non-compliance. To the extent that the property owner wishes to make any arguments regarding equity and reduction of the fine, that would be appropriate to be made to the town council after the Special Magistrate certifies and the lien is recorded. But I would respectfully suggest and say that based upon the specific language in the code, the only issue is the number of days that the property was in non-compliance.
If I may, I would respectfully refer to the section of the code that does allow the Special Magistrate to lower the amount of the fine regardless of the circumstance.
Okay, I hereby find that the magistrate's order dated, signed on September 2nd of 2020 in regards to the hearing that occurred on August 20th of 2020 was not complied with, and that the earliest date of compliance as per the respondents would have been 10/23. However, I do believe that there were extenuating circumstances in regards to the owner and the confusion with the contractors, and that the fact that it has already been removed and permanently removed, I'm going to go ahead and certify, but in the amount of $2,000. And it is hereby acknowledged payment of the one-time fine and admin fee. So I'm going to certify the order in the amount of $2,000, which shall, by certifying the order, it shall become a lien against the property and be recorded in the official record of the County, Florida. And hopefully now you'll be able to go ahead and retire that and get it all taken care of.
I mentioned one thing, though. You had mentioned in your findings that the canopies were finally removed on October 30th, but we do have proof and an affidavit that one of the canopies was removed on September 23rd.
I actually gave you to the 2030. It doesn't matter because I complete, even if you calculate it that way, the reduction I gave you is still way more significant than that.
Okay. Thank you very much.
Remember how to pick your battles.
I know, I just want to make sure the record reflected that. Thank you. Did you want these affidavits for your file?
That's fine.
Madam Magistrate, next on the agenda, we have number 7, Joseph Delisle. This is violation of the Registry of the Short-Term Rentals. This is case number CE 200461. The code officer Presenting this case is our short-term rental coordinator, Kristen Schumacher.
Schumacher, you previously been sworn, correct?
Yes.
And you are employed by the town of Fort Myers Beach
Yes.
in the capacity as the short-term rental coordinator.
Yes.
Are you responsible for, in that capacity, for enforcing the town's short-term rental regulations?
Yes.
Are you familiar with case number CE 200461 for the property at 4753 Estero Boulevard, number 601?
Yes.
Please tell the special magistrate how you're so familiar.
We brought this case to hearing September 17th, 2020 as an unregistered short-term rental. They had 14 days to comply, otherwise a fine of $250 per day would be imposed. Complying with the order would mean they would need to register as a short-term rental
Alternatively, not have short-term rentals.
or not have short-term rental. My last inspection actually was yesterday, but they still have a rental going, and I do have evidence in here that they added another booking for December. So starting October 1st, 2020 to today's date, which is 49 days, $250 per day fine, $12,250. There's a $75 admin fee.
So the town is asking for an imposition of lien in the amount of $12,325.
Yes.
Schumacher, I know I've asked you this question before the special magistrate, but how simple is it to register a short-term rental with the town?
Either get the application online or contact me, and I'll be happy to give you a registration form. $100 to register, $50 right now to renew, and good to go.
Have you had any contact with Mr. Delisle in that regard?
No.
He's made no attempts to reach out to town staff to register this short-term rental?
No.
Further.
Do we have somebody here on behalf of the property owner? No? Okay. All right, there's nobody here on behalf of the property owner. What is the town is requesting certification, correct?
Yes.
Okay, I hereby find that the magistrate's order that was signed on September 30th of 2020 in regards to the hearing that took place on September 17th, 2020 was not complied with and continues to be out of compliance. As of this date, there had been 49 days at the rate of $250 a day, accruing to the amount of $12,250, plus the $75 admin in regards to expenses and costs incurred by the town, brings it to a total of $12,325, which, because it's not in compliance, will continue to accrue at the rate of $250. I hereby certify that order in the amount of $12,325 and continue to accrue at the rate of $250 per day. By certifying this order, it shall become a lien against the property, and it will be recorded in the official records of Lee County, Florida.
Thank you.
Finished. Next on our agenda is going to be number 8, Timothy Thiel. This is the violation of the LDC Section 10603 and Section 10605 illicit drainage. The case number is CE 200214. The code officer presenting this is going to be Steve Wick.
Mr. Rick, you've previously been sworn and testified that you're employed by the town of Fort Myers Beach, is that correct?
That is correct.
In what capacity?
I'm the town's floodplain administrator.
And in that regard, are you also responsible for enforcing code section that was issued in this particular case, the drainage requirements?
You did.
Are you familiar with case number CE 200214 for the property at 464 Washington Court?
I am.
Was there a previous order or violation entered by the special magistrate for this property?
Dated March 5th, 2020. It was a order to have the corrected with a $75 administration fee, as long as it was corrected within 60 days. That date would have been May 4th, 2020.
Is the property in compliance as of today?
It is in compliance as of today. I saw that it was compliant as of the 31st of August 2020, and the previous evidence I have of having it been not compliant is on the 7th of August 2020. So sometime between those two dates, the problem was corrected.
So, based upon that information, have you calculated how many days the property was in compliance and the lien that the town is looking to impose in this case?
The total number of days is 119 days at $250 a day for a total of $29,750. And then there's an administration fee of $75. And I don't know if the gentleman paid that or not. The total amount is $29,825.
And the file contains the magistrate's previous order and photographs of the property.
It does.
Anything further, special magistrate?
All right, do we have somebody up here on behalf of the property owner?
I'm the owner. I'm Tim Teal,
Okay,
HIL.
so why did it take you so long to go ahead and get this drainage issue resolved?
Because it wasn't an issue. Talking about 600 square feet of an area that has been removed. It's basically a weed barrier that was there since 1961. Backyard I improved the drainage and the finishing surface. Was not a violation whatsoever. Because my neighbors called Mr. Wick and complained, I'm here.
Well, we're
And they're
already,
not going to go away.
we're already past the point of me making a finding as to whether the violation existed or not. I already did that in the previous hearing. The question is that based on what the officer testified to, somewhere between August 7th and August 31st, there was compliance. I mean, so that there was a change in the drainage system.
I spent $2,000 to have the weed barrier removed by Distinctive Rentals because I couldn't come down because I tested positive for COVID. I couldn't do anything personally.
That, I mean, you realize that's all the town wanted. It sounds like whatever you did, I mean, the officer was satisfied because he complied it.
And
Eventually.
I'm an engineer, surveyor, project manager. Does not make a hill beans difference for the runoff coefficient for that size property. It does not matter. The cul-de-sac still floods. It's not my fault. It always has when I bought the house. You can't prove that I was delinquent or deteriorated the property whatsoever. Every time it rains, and I have pictures and I forwarded to the town, floods. It is what it is. It's flat and it floods. Fort Myers Beach. Bought it on purpose, knowing that when I walked up to the property the first time, I was in 6 inches deep water.
I understand that. The point is that you first came in saying that there was no violation, but you did do something that satisfied the code
I
officer.
did only to satisfy a pathetic order. And it makes no difference. I spent money to satisfy an order because of politics.
Okay.
From an engineering standpoint, it makes no difference whatsoever.
Well, just so that you know that what I'm here to do is apply the fact as presented with the ordinance. So again, the finding of fact that was already done, the finding of violation that was already done, so we're here on imposition of fines. Okay, so certification. All right, I hereby
Whatever your fine
find,
amount is, I'm going to sue the town for what.
I hereby find that the order of the magistrate dated, signed on March 5th of 2020, in regards to the hearing that took place on March 4th of 2020, was not complied with within the time frame stated therein. And that was $119, 119 days out of compliance at the rate of $250 per day. Plus the admin fee of $75 for a total of $29,825. According to the evidence, the violation has been corrected. However, that is the $29,825 in fines and costs and fees have accrued. As such, I am certifying the order in the amount of the $29,825, which shall now become a lien against the property and recorded in the records of Lee County, Florida. Straight up to the town council.
Will do. See you soon.
Madam Magistrate, next on the agenda is number 9. We're moving in out of the imposition of liens. We're moving into new cases to be heard. This is Prasad Properties. This is a violation of the town's LDC Chapter 10, Article 4, illicit drainage. Grease was discharged into the town's MS4 system. The case number is CE 20-0315. Code Officer Eli Lee is going to be presenting the case.
Officer Lee, can you please state your name for the record?
Eli Lee.
And are you employed by the town of Fort Myers Beach?
Yes, I am.
In what capacity?
I'm a compliance officer.
And in that capacity, are you responsible for enforcing the town's codes and ordinances, in particular the Land Development Code and the section of the code that we're here for today?
Yes.
Are you familiar with the property at 1028 Estero Boulevard, which is the subject of case CE 20-0315?
Yes.
Can you please tell the special magistrate how you are so property?
Yes. So on May 7th, I was advised of the island when a worker called me because they was working early that morning. Invited me to come by Sunset Grill and see a truck that was out on the property. I go out there, meet with a few of the public works workers, talked about, where this grease came from, why they're here, and how goodness of it was going to the town's drainage. So we was out there for a couple of hours. The business opened, getting cones from public works and try to cone it off to let people know don't walk this way. And a lot of the grease went on to neighboring businesses where they could have opened up their restaurants until the grease got cleaned up. So it caused a lot of hindrance on other business owners. The grease trap overflow. So when the restaurant opened up, we talked to a few of the workers, and we notified them about, hey, what's kind of going on, what happened. A few of them said that this been here since last night. We just didn't do anything about it this morning. So we thought that was a problem. I told them that this is a $5,000 citation, but I'm going to work with you. Get this cleaned up as best as you can, kind of go from there. So I left, did my inspections that I had to do. I came back. I seen it was up, which is a good. Problem is that this row, which is a public department technician, he called me and told me that the workers that we placed around the drainage, if they clean it, if they water it or hose it down, it's town, Times Square is kind of the grade is going to slope down the water. So I told them, it's do the best you can because it's going to drain down, but we have the salt there to protect as much of the grease that doesn't go in. The problem is, resulting in the $5,000 fine, is that they remove the salt. They forcefully push the grease down. We have pictures of them. So in the folder, you'll see pictures of before, the morning of. We got pictures from local restaurants. The security cameras captured the grease just sitting there overnight. And then we got a picture of the workers just in the child drainage and the salt was removed.
The record, is it a violation of the town's code to discharge grease in particular into the
Objection
town's?
leading, counsel's testifying, Your Honor.
Allowed, the rules are, the rules are less formal. You can go ahead and proceed.
Is what took place on the property a violation of the code?
Yes.
Also,
So the code states that for illicit discharge, that no discharge that has contaminants in it are allowed to drain the MS4 system, unless it was just stormwater runoff, just contaminants can't.
did staff issue a citation or notice of violation to the property owner in this case?
Yes.
Is a copy of the notice of violation The file.
Yes.
The photographs that you testified about earlier, showing the condition of the property on date in question, also part of the file.
Yes.
Was a notice of hearing, today's hearing issued to the property owner.
Yes.
A copy of that also in the file.
Yes.
Obviously, the property owner's here, so they received notice. At this point in time, town has nothing further other than.
I have one or two questions before I tender it over to property owners. You mentioned that there was a protection put around the grease to keep it from going. Is that what you were talking about?
So that was like that when we got to the property.
Okay.
So we put the cone off to let people know, don't walk in this area.
Cone with the tape around.
Yeah.
Okay.
That was the purpose of all of that.
Okay, and you mentioned that you had pictures of them
Yes.
removing,
The saw,
yeah,
it's right here.
I don't think I have that one.
Your Honor, just for the record, I'm going to object to all these pictures because we've never seen them before.
Okay, you'll have an
There's
opportunity
no
to see them.
foundation.
It's.
I don't think I have that one, yeah. I don't have that one, I'm looking, oh, great, never mind, I got it, it was buried in there.
That's not a town employee removing.
Could, could
We take the
property owner be provided with copies of
You can have my whole file.
the pictures?
You never requested them to.
I mean, if I may
To request
ask,
evidence.
Officer Lee, just one quick question. Officer Lee, did you make contact with the property owner or the business owner and discuss the situation?
Yeah, so I met with a few of the workers. I believe one of the managers works in the kitchen. One of them is present. Spoke to him about, this is why I got a $5,000 citation. Got pretty heated. A lot of yelling in my face and everything. As far as to that, that's the last time I talked to them about the situation.
And just for purposes of my own, of orientation, with this picture, where there's the two individuals there, where is the drain?
The drain is right there where that sock is at, so you see them kind of just pushing down. That's where the town drainage is at. There's one right there, and there's another one diagonal in front of the business.
And the property at issue is right here?
It's on the left-hand side of it. The property that you're.
Oh, it's over here.
Yes.
Okay.
Where you circled that, there's another property, there's another drainage right there as well, that we kind of just socked off as well. There was two drains that we socked off.
All right, anything further from the town?
Officer Lee, were you able to trace back, I mean, did the property owners, representatives you spoke to, did they deny having, that the grease was from their business?
Objection hearsay.
Loud.
Go ahead.
So, a few of them on the day of, they said that, that's not the case, but as the day went on, that is, I agree. A partner of the restaurant said to me, public works, in attendance, that I had testimony about the grease the night before. I just didn't do anything.
Nothing further.
All right, whenever you're ready.
Sir, your ticket says that he violated Chapter 10, Article 4, right?
Yes.
And what's the purpose of that article, sir?
Illicit discharge.
Sorry?
Illicit discharge.
It's the only purpose of the whole article?
That's what I cited.
Well, and we were talking about MS4, sir. I don't know what that is.
As far as the town's drainage system.
Okay.
Hence why I put in the notes, there are no discharge allowed to MS4 except uncontaminated stormwater runoff, just to.
I'm sorry, I couldn't hear you, sir.
That's what the note says, and what I cited for, there are no discharges allowed to MS4 except uncontaminated stormwater runoff.
Right. And there are some exceptions to that, right?
Can you read that? I didn't hear, I'm sorry.
There are some exceptions, right?
No.
No, okay. You said that was grease, sir. Did you test it?
I had to go test grease. I didn't test grease.
Okay. You know what kind of grease? Was it bacon grease or oil or?
Nope, the worker told me that it's their grease from their grease trap. I told from a few of the workers, one right there. So.
Okay. And isn't it true, sir, that in order for the runoff to be subject to a fine, it has to be above so many parts per million of a contaminant. The minimum standard, sir, as long as you're below the minimum standard, then it's not a problem, correct?
Maybe. I guess that's
Do you know what the minimum standard is?
not the minimum standard.
All right, did you test for the minimum standard?
I didn't test grease.
All right, may I approach the witness, Your Honor?
Yes, you may.
I'm handing you a copy of Chapter 10 of the Fort Myers Beach Code. Show me where the standard is. How many parts per million do you have to be below to avoid being in trouble, sir?
Still looking for the standard?
Yes, sir. Well, let's look at section 10-605. If you go from the bottom of the page, second paragraph up, you'll see, read that out loud, sir, starts with water criteria.
05.
If you come down the page from 605, the pages of the code aren't numbered, I apologize. But if you go to section 10-605 at the top of the page, Your Honor, may I assist the witness? May I assist the witness in finding the page?
Definitions.
10-605. That's the whole code, just go to 10-605. 10-474, you're going to 10-605. There, sir?
From here.
The top of the page, it says definitions, right? All right. Down here, let's see, 1, 2, 3, 4, 5 paragraphs starts with illicit discharge. All right. It's not just town of Fort Myers Beach, like you said, is it, sir? Lee County as well, right?
Yes.
All right, so you guys have an MPDS permit, right, that you can pass on to the residents? Okay. You don't know if you, as a Fort Myers Beach environmental guy, has a discharge permit?
The city's operation of its stormwater system is pursuant to a state-approved system that is compliance with NPDS.
I understand, counsel, but I'm not asking what you know, I'm asking what the witness knows. How about that? Thanks for your testimony. Sir, if you'll go back down to, you see where it says in the bottom of the page, cross-reference?
Reference. Same page?
Yes, sir. Where it says cross-reference, bottom of the page, right above 10-606? Same page we're on, sir, all the way to the bottom.
Water quality criteria.
Right.
Okay.
Read that out loud, sir.
Here, cross-reference.
Right above it, start with water quality criteria.
I don't see. It's not on this page. Yeah, it's on the page. So repeat that, you want me to read again?
Water quality criteria.
Cross-reference, read it.
Yeah, right above it. Water quality criteria what? Read that whole
Meets
sentence.
minimum water quality standard as defined in the surface water quality standards of chapter 62 FAC.
All right? So maybe we'll find the minimum standards for particles there, sir. let's look at that. Here's FAC 62-302. Go ahead, that's the whole thing. Show me where the minimum water standard is that my client can be below to avoid fines, sir.
Your Honor, objection. The town's not under an obligation to prove a negative here.
I'll allow it. I think I know where he's going. I'm going to allow it for now. Good.
Surface water quality, correct?
Yes. What is the minimum water quality? That's what I want the answer to. What standard does my client have to maintain?
Objection, Your Honor. There's no evidence that the discharge is water.
I'll allow it. I'll give him, that's,
It's the illicit source. So what, water and oil, so what, no?
Objection, assumes facts. There's been no testimony by staff that this involved water.
also staying that. He has always said that it was grease.
All right. So what particles per million are we looking at, sir? What's the contamination level?
What? Grease or water?
Well, let me ask you this question, sir. When you got there, can we agree that discharge, it didn't present an imminent or substantial danger to the environment when you were there, sir, did it?
Objection. Again, there's no
What's your
testimony
objection?
that
I'm
the
ruining
staff
your
is.
case?
Sustained, that's not what he said.
So let me ask that again, sir. When you showed up there, your personal witness, what you knew, that spill was not an imminent and substantial danger to the environment, correct?
Objection. That's not the issue nor the
Judge, he's
testimony.
now,
I'll allow it, just answer that question.
I'm going to object to his speaking objections, Your Honor. If he makes an objection, he can cite the piece of the evidence code and stop giving the witness the answer in his objection.
Sustained.
Thank you,
Try to let him
counsel.
go ahead and testify.
Who you refer to? Is it the big puddle spill that you're talking about? Or, because when I went to the property,
Sir, here's my question. Let me just simplify it. When you showed up at the property, what time was it?
7 a.m.?
7 a.m. When you showed up at the property, in your professional opinion, they put you on as an expert here, sir, right?
No.
Well,
He's
he's
a
a lay
fact
witness?
witness as to what occurred. They've
Okay.
never
Sir, how
qualified
long
him
have
as
you
an
been-
expert.
Your Honor, I'm going to object to opposing counsel's
Yeah,
continued
let's
interjection.
allow him to
That's
testify,
inappropriate.
counsel.
The code officer, what, a year? Okay. When you showed up at the scene, was that a substantial and imminent danger to the environment? Right there when you showed up.
Because somebody inside the,
It was a substantial and imminent danger to the environment, correct? Yes. Okay. So according to this, though, you're supposed to enact emergency procedures immediately, and you didn't do any of that, did you, sir?
Objection.
Sustained.
That's not the issue before the.
But he even testified to the contrary.
According to this, sir, you're supposed to establish immediate emergency procedures, correct?
yes.
If the spill is an imminent danger, you didn't follow the code. You didn't establish any emergency procedures at the scene.
Sustained.
I'm sorry, what's the objection, Judge? I didn't even hear the objection.
Well, now he wants to hear the basis of the
What's the
objection.
You're changing- you're-
That's what I've been asking you all day, Counselor. Cite the legal objection. What's the legal
You're
objection?
changing the testimony.
He's,
Okay, so I don't understand how I'm changing this testimony. Sir, did you or did you not engage in emergency procedures when you arrived?
One of the procedures that I've done was my best with public works and contain the source.
Okay, so do you know the emergency procedures that are in the code?
Sorry, I do not know the emergency procedure.
Can we say you didn't follow any of them?
objection.
Same thing,
Sustained.
I'll move on, Judge.
Okay.
Sir, if it wasn't an emergency, what were you supposed to do?
Was it an emergency?
If it was not an emergency, if you got there and it was a spill, but it was not an imminent danger to the environment, what What's your course of action supposed to be as the code officer?
Work with the property owner or whoever's at the property about cleaning it up if it's not imminent danger. But the problem is, and I stated earlier, that there was some grease spillage already going into the grease trap.
I understand, sir.
Didn't know it at the moment. We know as much as we could, but we know how dangerous it was until the water department technician got out there. He see how much grease was in the trap. Hence, if you look at the picture, just a substantial amount of grease already in there.
Okay. Did you shut it down then? Shut down the whole place?
The power shut down the whole place.
But what about, sir, if it's not an emergency, there are procedures in this code that you as the code officer are supposed to take. Did you do those?
But
Assumes, if he wishes
yeah,
to
but so
enter
that
in-
wasn't the case of speculation.
Yeah,
That's,
if he wishes to provide the witness with a copy of the,
Counsel, is it hearsay? What is it?
assumes facts not in evidence,
Thank you.
okay?
I'm asking him a direct question.
And you're asking him to testify to a code that you have not entered into evidence.
I'm gonna sustain that because I don't believe that you're asking him to speculate if it wasn't an emergency.
Sir, you have a copy of the
Your
Fort Myers
Honor,
code right in front of you,
I
right?
need for the opposing counsel to speak into the microphone.
Yeah, you gotta stay over there.
Sir, you have a copy of the Fort Myers code right in front of you, Fort Myers Beach code right in front of you, right?
So, yeah.
Yep. That's one of the documents I gave you, right, sir? Yep. Ever seen that document before?
That's not have.
Read it.
Read it. Yeah.
All right, what part pertains to your job, the specific job that you're required to do as a code enforcement officer at Fort Myers Beach, sir?
Parts of the document, what it says,
It describes what your duties are in there, right?
enforce the town codes and ordinances.
Sorry, I didn't hear you.
Enforce the town's code and ordinances.
Okay, where is that?
Wait. I think we're really getting off track now. All of a sudden now, you're on the spot, on the witness. We're here to go ahead and discuss what happened at the property, not whether he did his job or not.
Well, ma'am, I beg to differ, because if he didn't measure the grease, it was grease, we don't even know that it was. But assume we take his testimony for it. He didn't measure it, and there's a minimum that he can be not above, and there's no fine. So that's what I'm trying to establish, that it was never even tested. Nobody knew if it even came into the degree that was required for a fine.
Oh, yeah.
I'm sorry. This pole, I'm sorry, ma'am, this pole is in my way, and it's making me
That's
kind
okay.
of peek around it. I'm sorry, Your Honor. So, that's fine, Judge, I can move on from there.
Yeah, definitely move on.
Now, sir, you said that they put some sand around it, right?
Property owner or the town?
The drain,
No, they put a stock around it.
around the,
The town's drainage, yes.
well, you're gonna have to help me out, sir, I'm not all that bright. So, when you got I gotta stay back over here.
We just pointed to you, or from here or
I
something?
just wandered. When you have a grease trap, there's something coming out of the ground, right? Do we have a picture of that?
I believe we do. Give me a second. I believe it's in this picture. Right here.
Might be helpful if we mark these pictures, Your Honor, can we do that?
I'm not exactly sure if we're gonna be, just raise it and let me see it
The
again.
problem is then I can't keep track of it, I don't know what picture
I
we're
would,
talking
I would
about.
love, it's a great idea. I just don't think at this point in time I have a massive amount of pictures
Can we just
with
write on
me.
them, Judge?
Sure, go ahead and call one and put a number to it.
Yeah, because then I'm gonna use that. All right, sir, may I come over there, Judge, and get the picture that he says shows the drain?
Trap, not the drain.
Trap, I'm sorry.
Okay, so-
Can I speak into his? Is that all right if we speak together? What is,
I'm not exactly sure if.
We're trying-
Yeah,
we are
we're
trying
trying to
to-
go ahead and keep
Your
them,
mask on.
especially without your mask on.
sir, there's a piece of caution tape that's in this picture. And is the grease trap this white thing that sticks up right there?
Which picture are we talking about? I need
Well,
to
I'm
be
gonna
able to see
label it number one, Judge. It is this picture. I don't see it up on the thing there. So,
The water technician sent
Let's
me.
just do this. What I've circled here, sir. Thank you, thank you. What I've circled there, sir, I want to see if that's the grease trap or not.
Now, what else?
This is one of the pictures that the water technician sent me. There's others with the white pipe.
Yeah, so the question is that white, it's got a white cap on it, is that the actual grease trap?
Said, that it is. I said the water department technician sent me that and said this is where it was coming from.
Okay, so that's, can you say that's, whatever it is, whether it's a grease trap or a pipe, whatever it is, that's where the contaminant came from,
Someone,
grease or whatever it was.
Object. I think the testimony that Officer Lee was to the best of his knowledge, that's the
Again, what's
place
the
where
objection,
the.
Counselor? We have an evidence code.
Here, it's very, very informal with the
Well, which
evidence
rules are we
code.
gonna follow,
Some-
Judge, so I know? Which rules are we gonna follow? Let's
So-
list them.
Evidence rules are gonna be very flexible, so you're gonna have hearsay's fine, leading's fine. An objection, yeah, I agree that there's gotta be a basis for it, but
All right, so the question was, sir, do you believe that's where the contaminant came from?
I say that's the picture the water technician sent me. The rest of the grease trap.
And you did not see any contaminant there, correct, sir?
The property I did, but I didn't take a picture of the water technician.
Okay. So that is where the contaminant came from?
The water technicians, I believe so.
Okay, but you didn't see it?
Didn't inspect that area.
Okay. So you didn't see grease coming from that area?
In grease that was near the area, which is that puddle. And
Didn't see where it
my-
came from, did you,
My
sir?
main job at the time was to kind of seal off as best as I can, so people,
Didn't see where you came from, did it, sir?
the water technician did.
Okay. And he's not here, right?
I believe he's heading here.
let me go ahead, this is, we're taking a long time, and I know we still have audience members here. Yet I think we've digressed again. It sounds, and I'm gonna summarize, normally I don't do this, but I'm gonna summarize what I'm hearing from both sides. For the most part, he's saying that when he got there, he saw the grease, and he had tried to assist the property owners in dealing with it. It sounds like he took testimony, and they admitted to the fact that the grease was coming from that
Where's
property.
that testimony, Judge?
He said it, that's what he said, testified.
So rank hearsay is okay? We don't have to have
Yes,
anybody here to
didn't you
testify?
hear me say that, that hearsay was perfectly fine?
Okay.
Oh, and I understand you're trying to go to the source portion of it, but his testimony wasn't that he saw it from the source. He got testimony saying that it came from that property, and he saw it that it was grease. I understand you had a much better argument where you were trying to go down the route of, well, maybe it wasn't as bad as you're painting it to be. But the fact is that he even said he wasn't gonna cite them. He was trying to help them. And then they go behind and they went ahead and the employees pushed the grease into the
Sand.
drain.
Thought he said the sand.
Was it the grease or was it the sand?
That they removed the sand.
The grease.
Yeah, they pushed,
Saw and pushed the grease.
and they pushed the grease. That's what that picture that I was trying to find,
I'd like to
that I
see
was
that, too.
asking for.
I'd like to see that too. The point is, Judge, if you want to summarize, what we have here is we have a spill. We don't know how large it is, but I'll get into that with him
Okay.
on cross if you want me to. But we have a spill that was cleaned up in 2 hours. They were told they weren't going to be fined. They did everything that they were told to do. They completely remediated the area. And now we have somebody trying to fine us when they don't know that's the only place grease came from. They don't know how much it was. They don't know what the parts per million are supposed to be. He might have been under the limit.
You have-
Judge, I'll just demur to the evidence at this point.
Do you have evidence of that it was cleaned 2 hours afterwards?
Judge, it's not my place to bring evidence. He's guilty, he's
It
innocent
is,
until
it is,
proven
when
guilty.
it comes to code enforcement counsel, you know that it is the respondents or property owners' burden to go ahead and prove that the violation was corrected.
We have a witness and pictures, Judge, but at this point, they haven't met their burden. They have to prove what they've alleged, and they can't do it. They don't even have anybody who saw the grease. They don't know the particles per million. Come on.
Do you have evidence that it was remedied without it going into the drainage system?
Well, I'll get to that, but did they have any evidence
We would
that...
be done and over with. All I'm asking, if you have that evidence, present it so we can move on.
All right, let's do that. I guess, is the state done?
No, we're gonna have a rebuttal.
Oh, let's get on with it.
Oh, are you finished with your case in chief?
No, that was cross-examination of your witness, dude. I haven't even started yet.
Then,
Does the state rest so I can put on my case?
All right, do you know what, at this point in time, how much longer would you think this is gonna go?
Depends on the witnesses, Judge.
And then, it sounds like it's gonna go for a while. Why don't we table this one, move on to everybody else, and leave this case for the end?
Okay, so my guy has to pay my hourly fee to be here.
If you're gonna be here forever and ever, I mean, I'm concerned about the
that's
rest
the
of
point,
it.
Judge. This is
I'm gonna
prejudicial.
do
My
a
guy's
democracy
ending
again.
I'll ask Mr. Lee a couple of quick questions. Officer Lee?
I have an email. We have an email from Chris Rose saying. Who's Chris Rose? Water Department. Chris Rose is who?
And, Officer Lee? Going back to the code that was provided to you by opposing counsel. You look at section 1606, definition, 1605, the definitions again.
Sorry, 16?
16605.
Chapter 16, Section 605. Okay.
Okay. Give it to you. Let me-
All this.
You read the definition of illicit discharge.
Discharge or illicit stormwater discharge means any to the town of Fort Myers Beach not composed entirely on contaminated stormwater. Discharges with firefighting activities.
Mr. Lee, does that definition, for which that is what the property owner's been cited for, is that correct?
Correct.
That definition of what constitutes an illicit discharge include or is it anything that's not uncontaminated stormwater?
Correct.
Okay. Was the substance that you observed on the site when you visited, was it uncontaminated stormwater? Was it a discharge made in accordance with a county or town issued development order?
Yes. Oh, no. Oh.
Listen very carefully to the question. Think about it before you answer. Was it a discharge made in accordance with a county or town issued development order?
No.
Does the property owner have an independent MPDES permit, to the best of your knowledge?
Not that I've seen.
Was the discharge the result of a firefighting activity?
No.
Was it otherwise exempted under this article, to the best of your knowledge? Nothing further.
Couple follow-up I wasn't even done with my cross, Judge. But, sir, so it turns out there are some exceptions that you didn't know about, right?
That's an answered objection.
No, I asked him if there were
Let me go ahead
objections. He
and-
said
I'm gonna
no.
allow it.
Counsel, you read them into the record. Now I'm asking him if he wants to correct his testimony. Mr. Lee, there are some exceptions, aren't there?
Yes, from the code I just read.
Okay. And, testified there was some discharge coming out, but I think you testified earlier that you didn't test it for anything, correct?
Didn't test it, no.
I don't have anything else for this witness.
All right, do you wanna go ahead and,
Put on Terry Passat.
put on your case?
We swear in here or no?
Oh, yeah. You swear affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
All right, sir, state your full name.
Terry Prasad.
Okay. If you want to pull down your mask to speak more clearly for the record, just make sure you face me. Don't face any of the crowd, okay? State your full name for the record. It wasn't clear to me.
Terry Prasad.
Okay, and we're here today, this is your place of business that we're here about?
Yes, Your Honor.
All right. So tell me what happened as you know it.
On May 6th, our main sewer line backed up. Immediately, it started to seep through the grease trap. It was basically water, and we shut our kitchen down because there's two lines that come out of our restaurant, one for the kitchen and the grease, and one for our main sewer line.
Those connected in any way?
They're connected. After the grease trap separates the grease and the water, it sends the water into the main sewer line.
All right, so walk this through. Grease comes out of where? Your fry laters or?
No, our fryers are totally contained system. Grease from the fryer goes into a recycling system, and then it's picked up by a company.
What about the grease in the grease trap? Because that's what we're talking about.
Grease from the grease trap is basically from washing the pans and the pots. That's basically where our grease comes from. It does not come from our fryers. It does not come from.
How does it get into the pipe? Who puts it in the pipe?
It'll come from, again, washing the dishwashing area.
So it goes down your sink drains?
Yes,
Okay. Now, how does that sink drain know it's grease instead of water?
because that system is plumbed totally separate. The grease, all the kitchen pipes goes directly to the grease trap. The pipes from the restrooms and the bar area goes to the main sewer.
All right, so how did this happen?
So we've been in operation for 5 years. After the pandemic, we were shut down. What the plumber is saying that because water wasn't going through the main line, things just kind of hardened. And when we open back up, we got an excessive use on our bathrooms from all the visitors to Times Square, from the other restaurants. So we have a significant amount of usage in our restroom. The main sewer line plugged up, and I mean, we all own homes, we all live in places where you never know when that's going to happen. We didn't know it was going to happen. When that happened, it refused to accept water from the grease trap, so the water on the top of the grease trap started to trickle out. Once we saw that, we thought it was the grease trap. We immediately shut the kitchen down. We called the grease trap company. They came out right away in the morning. They said it was not the grease trap. They pumped it out, and it was still not flowing. We called the plumber that right away. He came out about 11 o'clock, unplugged the drain, and then everything was fine.
So where was it plugged?
It was plugged about where they're showing you where the grease trap pipe is, about 5 feet away from that in the main line.
So when were you first aware personally that there was a problem?
About 8 o'clock that night, they called me and said there's some water starting to trickle out of the grease trap. So, I told them immediately, shut everything down in the kitchen, don't use anything. But we kept using the bathrooms because we didn't think it was the main line. So, and then, again, people from Times Square, from the other business, they come into and use the bathroom. So, the bathroom did have an amount of use. That water, because it was flowing out to the grease trap, might have had a little bit of trace of grease, but it was basically sewer water, so it was stinky, it was discolored, as you can see from the pictures. What my guys did immediately was create a sandbank around it, to stop it from going into the drainage and get it back under the building so you can see back into the sand and not into the source, not into the stormwater system.
How did they put sand there?
The sand will absorb the water and it will dry the sand back out, so it doesn't go onto the beach or goes into the.
And they just knew to do that?
Yeah.
Okay. What happened to the sand?
We bring the sand, put it back in the parking lot, let it dry out, and then we put it. We were scooping sand. Our building is about 3 feet off the ground, so we can take sand out of there and put it back.
So how long from the time it first started leaking to the time it was contained and the time it was repaired and operational again? Times I'm asking you for. 3 times. The time you first became aware it was a problem, the time it became contained and at least wasn't a growing problem, and then the time it was resolved. Give us those 3 times.
Okay, so it happened about 8 o'clock that night. We shut down the kitchen. We cleaned it up as best as we could. The grease trap company could not come until that morning, so the guys cleaned it up as best as they can. When they got there that morning, there was still, as you can see from the strong pictures, there was stain on the bricks, but there was no grease. There was just one little puddle in front of the building that had trickled out after we closed down and after the staff left, after they cleaned up the original spill. When they came that morning, we met Eli. He them,
Eli is who?
the town.
Mr. Lee.
Mr. Lee. Kevin, who was here also, he called me right away and told me that, town is back here, we're cleaning it up. He told us, you gotta clean it up right away. He told him, can I have an hour? He says, no, you gotta clean it up right away. They started to clean it up. They got it all clean. Another code enforcement officer came to them and said, you guys have a pressure washer? He says, yeah. He says, can you guys pressure wash it? Sure. So they took out the pressure washer. After everything was clean, after all the grease was removed, just to pressure wash the area. That's why the sock was removed, because when you're pressure washing, there's a lot of extra water. But there was no grease because they, as you can see from the picture, you can probably label it here, we removed what we thought was contaminant with sand, not pressure washing it down the drain. So,
Is that why they think you were pushing it back down the drain?
yeah, because the other code enforcement officer came and says, why don't you guys, if you guys got a pressure washer, why don't you just pressure wash it? So that's what they were doing.
And this is a picture of what?
That's them getting rid of the water, not putting the grease down the drain.
Who is them? Who's in this picture? Identify them.
That's George, and that's one of the kitchen workers. We called in them immediately that morning to make sure the situation.
And is there any grease here where they're cleaning up?
No, there's no grease there.
Mark that as picture number 2.
Which one's that one?
I also have a
Okay.
picture of grease trap, or the core line, showing that there's no grease in the main line when they opened it up that morning. Because they called the pumping trucks out, so we were out there looking at the picture, looking inside. This is what it looks like today. This is their picture of this line.
Make sure I understand what I'm looking at here. So first, describe this picture in my right hand.
That's the storm drain.
How was that picture taken?
They took their picture. This is our picture.
Which picture is
Their
that?
picture is very blurry. You can't
I'll
see
straighten
it.
it out, Judge. Give me just a second. So this picture that I'm holding in my left hand, I'm going to mark number 3. And what is it a picture of?
That's the storm drain that they're claiming that we put the grease into.
Okay, and who took this picture?
The town took that picture.
Okay.
We
And
took
what-
our picture besides them, and this is our picture,
When was this picture taken?
on May 7th.
What does this picture show you? What's significant about this picture?
Well, it's showing you the water that's in that catch basin, and if you look in this water, you cannot see any grease floating around. Grease is white, the color grease is lighter than water, so it floats on the top. So
Okay.
you'll see that grease on top here.
I don't understand. How is this picture taken looking at the drain? Is it looking into it? Is it looking
Yeah,
from
just
above?
looking, directly above it.
Okay. And what is this white piece here?
That's the water. But their picture is very blurry. They can't even tell what's in
And
there.
what's this?
That's just you see the jagged from the
Okay,
the
so that's a
contours,
piece
yeah.
of cement.
But this is our picture.
And then it was taken when, sir?
That was taken May 7th, as soon as the truck got there, because we were still watching what was going on.
May what?
May 7th,
7th.
yeah.
And had it been cleaned up before May 7th?
No, they're claiming that we put grease in there. There's no signs of grease in there.
No, sir. What I'm asking you is, had your grease problem been resolved? Remember, I asked you to tell me that date. When was your grease problem resolved?
It started May 6th that night. It was cleared up May 7th. The plumbing company was there about 11 o'clock that.
And how many gallons of water? You said you use a lot of water. Do you have any idea how many gallons of water run through your business a month?
Yeah, we do about 60,000 gallons a month. That'll equate to about 2,000 gallons a day, which would equate to be about 100 gallons an hour.
All of it's
Overruled.
And it was leaking about how many hours, sir?
Less than 2 hours, sir.
All right, that's all I have for this witness right now. I'll reserve the
In the file, I do have one question for the town. In the file, there's an invoice, for work performed by Mitchell and Stark Construction Company. I haven't heard anybody testify about that.
I understand that issue's not before the court today, Judge. It's set for another day.
Is that the case? Is that,
That's
Part of this case, it's
part
part
of
of
this
this file.
case.
that's why I'm asking about it, because it's in my file and I
That
haven't heard anybody talk about
invoice-
this.
I understood there was one case, today, and then this finding, the RECLA issue, it was for another day. I didn't understand we were supposed to do RECLA today as well. I don't see that anywhere.
The invoice is reflective of the cost that the town incurred in cleaning up this spill.
Okay. And your understanding of that was what, sir?
You are under the impression that we're here for the citation of illicit discharge.
Only.
Only, yeah.
Correct, but so there was a cleaning associated. Well,
There's
that's
a
what the
cleaning.
town is alleging, that there's a cleaning associated with it.
So in discussing this with the council, it was like, we first need to answer the citation to show that, we were not negligent. We did not put any grease down the sewer, the storm drains. It was an accidental discharge, from our,
So I understood that's for another day, Judge. Is that not correct?
It appears that I'll tell you what my understanding is that they're seeking to impose the cost of that
Yes, that's correct.
cleanup as part of what we're on here today.
Well, my understanding was just for the fine, Judge, but they closed their case and didn't put on any evidence. So as far as I'm concerned, they're barred from now putting on evidence of anything else. I asked them specifically, do you close your case? Yes, that's why I put on my witness. So as far as I'm concerned, that's done.
Have any questions of Officer Eli? My response was no.
Well, I asked specifically, Judge, if he closed his case, and you said yes. I had to ask it 3 times. We can go back on the tape and see. But you closed your case, Counselor. Now you want to reopen it? Come on.
I do agree, he did close, but I still do want to know about this, because I do have 1 or 2 questions about it.
Well, Judge, let me say
And I'll
this.
give it the way that I think is,
The problem is, Judge,
Appropriate.
to go to the RECLA, he hasn't had the proper constitutional due process notice. They didn't follow their own code. They have to give him certified mail, they have to give him so many days, et cetera. They didn't do any of that. So I would object to going into that on a due process argument with respect to the 14th Amendment of the United States Constitution,
But this is
Article 1,
something he hasn't
Section
seen?
9 of the state constitution.
this is something that your client hasn't seen and you haven't seen?
I haven't seen it, certainly not, Judge. I was only hired for this today.
Okay.
Mr. Prasad just stated that he's aware of this.
Well, he's aware that it's out there, but he understood it was set for a separate day. I mean, that's what he told me this morning.
If, Your Honor, if one looks at the Chapter 162 in the town code, it specifically authorizes municipalities in the town to pursue cost of compliance.
I understand.
Most certainly does, Judge. It also requires them to do certain things about that little thing called the Constitution.
And I
we
understand,
complied with it.
both sides. Let me go, everybody's assuming that I'm gonna go ahead and give it some type of weight that maybe I'm not. So everybody's jumping the gun on this. Let me ask the question. Okay, we have knowledge in regards to this invoice here. In regards to the work that was done, did it only impact this property, or did it go into the whole block? Oh, we have you, Ms. Jordan, do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, or nothing but the truth?
Yes, I did.
Okay.
So, Judge, we're back in the state's case.
I'm asking questions about this.
Right, but he's a new witness I've never seen before, haven't had a chance to voir dire.
Who is this person?
We're back in the state's case.
Well, if counsel will allow me,
Go ahead.
can you please state your name for the record?
Christopher Rowe.
And are you employed by the town of Fort Myers Beach?
Yes, I am.
In what capacity?
Homeowner complaints and utility technician.
Are you familiar with the circumstances of the case that we're here for today?
I was there firsthand.
Okay. Are you familiar with the cleanup activities that the special magistrate is inquiring of? Mitchell and Stark invoice.
I was there while that was being done as well.
To her, I answer her questions to whether or not work that Mitchell and Stark was for this particular incident or a larger work?
No, they were there specifically to clean the grease and contamination out of the pipe so they would not flow into the back bay.
Invoice here says grease removal Times Square. My question is directed, I understand that assuming all the facts that the town is presenting are the way it happened, the grease would have gone in. How far would it have traveled and how much cleanup had to be done for there to be a $13,000 bill in there? In other words, and how are you able to allocate that came directly from this property and that it wasn't a problem with other businesses?
The system holds a certain amount of water based on the water level. So the second the grease touched it, it spread throughout the whole system inside of Times Square. Plugged it off to prevent it from going any further. Its two exit points go down Old San Carlos Boulevard and Crescent, which at that point would have entered the bay.
So those two areas are basically isolated, so that the cleanup can
We
happen.
managed to isolate them before there was any contamination of those two areas.
It was successfully isolated. And then once they're isolated, the part of the cleanup is only that area that I was isolated?
Yes. 13,000 was for cleanup and contamination removal of the Times Square storm system.
How long of a span would it be from point to point of the containment?
From the beginning
Approximate.
of cleanup to the end of cleanup, or
From,
we were in there, out of there in a day and a half, roughly, because they had to take a break.
linear footage, let's put for a second.
Oh, linear footage of
Linear
the
footage from
Times
end to
Square?
end.
That one's a little tougher without having my GIS system in front of me.
More or less. Is it more than,
I'd say at least 400 feet of linear.
more than a
linear
block or half a block or?
footage. If you combine it, it'd be about a block, a little more than that, yes.
Okay. Were there any other reports of any other businesses having issues with their grease traps that time period?
Not that I am aware of.
Okay. Are you, Mr. Prasad, are you aware of any other businesses having issues with the grease traps during the time period?
I don't know what you're aware of.
No, I'm
Not aware of? You can go ahead. I'm sure you have questions for him, so go ahead.
Thank you, Judge. Approach the witness.
Yes, you may. With your mask on.
Big mouth with his mask, Judge. Does that surprise you?
Can't help you with that.
Sir, I'm going to hand you some documents. Identify those documents for the court, please, sir.
You're part of the material haul away sheets that Mitchell and Stark did.
What does it state that the material was they were hauling away, sir?
Because it's a mix of water, grease, and degreaser.
If it was only grease, it would have said that, right?
I would imagine so, but it's not only going to be grease only because the water is based on a water table system. It's perforated so that the water can rise and lower inside the pipes.
Is there a standard by which there's a number, and if water is contaminated above that number, it's contaminated, and if it's below that number, it's not contaminated?
Based on general standards, yes. Like contamination can be a wide range of things. Minerals inside groundwater that's being deposited, outside contaminants such as grease, degreaser, bleach, regular household cleaners, fuel, oil.
And we got a test for those, right?
As I know, yes.
Do we do any testing here at this site?
I am not sure of whether they did or not.
Well, let me ask you this, sir. Do you personally know of any testing that was done at that site?
Not that I know of.
So if I were to ask you what the standard was for that water, would you be able to find it in the Fort Myers Beach Code?
Probably not right offhand, no.
The Fort Myers
I don't
Beach,
do code.
you're not a code enforcement officer.
No.
Okay, I misunderstood. You're the worker who cleaned everything up. I thought you were
I
also,
also do storm.
Okay, I thought in addition to that, you were code enforcement. No. So that ends my questions for you, sir. Thank you.
May I ask questions, Mr. Prasad? Mr. Prasad, it's your testimony
Are you
that
completed
there was a
your-
discharge.
I just want to know where we are, Judge. Are we back in my case and he's doing cross?
Yeah,
I'm
no,
all confused.
I allowed him to go ahead and do the explanation of the invoice, but we're still on your case.
All right.
That's why I came back.
Thank you, Your Honor.
Mr. Prasad, is it your testimony?
Wait, hold on. He's not done yet. Oh, are you done with that witness so he can cross?
Yes,
Oh,
ma'am.
okay.
We're ready for counsel's cross.
Mr. Prasad, as I understand your testimony, there was a discharge of grease from your business, correct?
There was a discharge came from our,
Of grease?
that was caused by our main line, not of grease, no.
Okay, what was it?
There was water from our septic system.
Did you test it?
Because I did not test it, but when the plumber showed up, he said the sewer line is blocked, so that's where the water came from, so it's a
There was no grease whatsoever in it that you tested? Was it all water?
I did not test it, so I can't say if there was grease or not in there, so.
So, let me ask you this. To the best of your knowledge, was the discharge from your property entirely of uncontaminated stormwater? Not wastewater, not potable water, but was it, to the best of your knowledge, not composed entirely of uncontaminated stormwater?
I can answer that question.
It rained. Is there any evidence of rain, to the best of your knowledge, when you did visit the site? Is there any evidence of discharge of stormwater from your property or any adjacent properties into that storm drain?
And if there was high tide, they can be, yes, but I was not there. Answer that question.
You have a county-owned or city or town-issued permit for that discharge? Yes or no?
I have a permit from the town to have a sewer line there and to have a grease trap there. And
Listen,
accident, the sewer line blacked up, and there was nothing I could do about it, but act upon it immediately, which I did. I had the plumber there within an hour to clean it up. I had my employees out there to clean it up, but the town wants to bully you, and
That's enough. That's enough.
I appreciate your answer, Mr. Prasad, but that's not what I asked. So let me ask it again and listen carefully. Please. Do you have a permit from the town or from Lee County to have discharged material? Let's just call it that for the moment.
were you there? to
Answer
see
his
what-
question. His question.
You testified that there was a discharge from your property. Isn't that correct? Okay. That discharge that you admit is from your property, did you have a permit from either Lee County or the town for that discharge?
It was
Yes or
not an
no?
intentional discharge, sir.
And that's not my question. Do you have a permit for that discharge? Yes or no?
No.
Okay. Thank you. Do you have your own on-site NPDES permit for that type of discharge?
Again, it was an accidental discharge.
Just
I
answer his question.
appreciate your explanation, but that's not my question.
No.
Okay. Was there a fire event there that resulted in this discharge? You've seen the photographs. Okay. And you don't, these photographs reflect the condition of the property and the storm drain on the date of the discharge took place.
I have the pictures of the storm drain that I took that's very clear compared to your pictures, and it clearly shows that there's no grease floating in the storm drain. I can show you
Again,
that.
all of the photographs, you've seen them, correct?
That's of Times Square, and it also shows the sand that was used to remediate that situation.
I'm not disagreeing with that. I'm simply asking, do these photographs, including the ones of the storm drain, accurately reflect, as best to your knowledge, the condition of the property at the time the photographs were taken?
I was not there, so I can't.
Okay. To the extent that you looked at them and you then took your own photographs, those accurately reflect the condition of the property at the time.
Pictures I have that were sent to me
You have the stormwater from the storm drain that was removed by Mitchell and Stark. Did you have it sampled?
Was not given the opportunity.
You
Was not given the
sample it? Did
opportunity
you
to
sample
clean it,
any of the materials?
because we didn't even know that the town was bringing in.
Just answer his
a cleanup.
question.
No, we didn't.
You are aware that the town hired a third party to come in and clean this discharge?
No.
You're not
There was
aware?
No notification of such services that was going to be called in.
Did you see anyone clean that area?
We cleaned up the Times Square area.
After the incident, who cleaned up the discharge?
There was no discharge into the storm drains.
Who cleaned up the discharge?
I think
If you,
from the invoices you sent me, it looks like Screw Environmental. Again, they're claiming that they cleaned up 19,400 gallons of water, and we discharged less than 0.001% of that water that day.
you do admit that there was a discharge into the system.
I did say there was some water that trickled out of ours.
You understand that once oil hits water, it expands exponentially to the,
Objection, lacks personal knowledge to answer the question.
Sustained.
based upon your operation of restaurants, you agree that water disperses in, grease disperses in water?
That was on top of water.
It spreads, generally.
I didn't see anything from my
No,
picture.
no, no, I'm not asking them, I'm basing it on your personal experience as a restaurateur. When you see water, a body of dishwasher, and oil hit that water, it spreads generally. Do you agree?
I don't agree with that.
What happens to it? It sticks there as a globule,
That's what I was saying, it'll sit on top of the water.
it sits on top of the water. Okay. Further questions?
Prasad, do you happen to have, you referenced a plumber's invoice. Do you happen to have that invoice? Please give it to your attorney, present it to the council before presenting it to me.
I just have one follow-up if I'm honest.
Okay. With Mr. Prasad? You can redirect, yeah.
I'll let you look for that, and then I'll ask you the question.
From the clock, and that's from the
The deputy approach you.
Yeah, he's gotta go, it's gotta go to him first, and then I'll take it. There, no.
All right, so I just have one question. I'm a little confused about the whole oil thing. So what is the grease that comes out of your grease trap made out of?
Not that much grease. Basically, all it comes from washing the pans and pots.
But is it oil? Is it animal fat? Is it kerosene? I mean, what is it? What goes into that trap?
We use a protein-based oil, so it's not harmful to the environment.
And protein-based means
I mean-
it congeals into clumps, right?
Yep.
All right, no further questions.
Okay, we're gonna do closing.
Your Honor, the property owner has very simply and straightforward been issued a citation for the illicit discharge or illicit stormwater discharge into the town's stormwater system. The definition of what constitutes an illicit discharge into the town's water system is very simple, very uncomplicated. It's anything that is not composed of uncontaminated stormwater. There are several exceptions to that. Discharges that are made pursuant to an issued permit, subject to a discharge that already has a separate MPDS permit, or pursuant to a firefighting incident, and then the provisions of, as stated here, or otherwise specifically exempted under this article. There's been no testimony that this that this discharge was comprised of uncontaminated stormwater. Been no testimony that this was.
Judge, I believe that whole line of closing violates the golden rule.
Again, rules of evidence and are much less formal here. You can proceed.
We're left with, according to arguments that have been made, this is arguably somehow exempt under some other provision of the town code. There's been no testimony to that effect. Been supposition, best. Based upon the evidence of testimony, we certainly believe that the evidence, including the testimony of the property owner who admits this discharge, and that this material did enter into our stormwater system, it constitutes, by definition, an illicit discharge into the town's stormwater system. We've met our burden of proof to showing that there's a violation of our code. With respect to the cost, again, the cost of cleanup, the testimony has been that this oil spread, this material, this discharge, we sealed off the system, and within that system, we had to pump out and clean everything that was in that sealed off area. As a result of the size of that area, the cost is set forth in the invoice that's in the record. And we'd ask that the special magistrate find the property owner in violation, assess the fine in the citation, or the property owner to reimburse the town for the cost of cleanup, as provided for in state law and in our town code.
I think this is real simple. That's the one thing opposing counsel and I can't agree on. There was some sort of discharge, Judge. I don't know what it was. We have conflicting testimony. One person says it was the state has their own conflicting testimony. One of their experts says it was only oil. One of them says it was oil and water. So back to the parts per million now becoming very relative. There is a number that's defined in the CFR, the Code of Federal Regulations, that specifically denotes the exact parts per million that you have to be below in order to be in compliance. And the Code of Fort Myers Beach cites all these RCLA and CERCLA standards and says we adopt them. So they got to show that he was above the standard before you can start levying fines. And Judge, I understand that's a lot of money. But we're here today, and we haven't seen any of the, had a chance to go through and subpoena or depose any of the witnesses for $30,000. We need to do that. There's no due process as to respect to that. But we would ask today that you don't find there was a violation. Part of the code says if there's an accidental spill, it's not intentional, you need to do these things immediately. When they showed up, heard Officer Lee testify, it was a substantial emergency issue threatening imminently the community. But he didn't take any action consistent with that testimony, Judge. Neither did he take any action consistent with the testimony that it wasn't an emergency. All of that spelled out in the code. Were there exceptions? Mr. Lee said no, there's no exceptions. Well, then how could he determine if my client was qualified for one of the exceptions? I mean, at the end of the day, Judge, there was a discharge. It was not intentional. You've heard that. What this says is if it's not intentional, you have to do all these remedial things immediately. That's true. It also says if you do those things, you're not going to be subject to further discipline unless it was intentional. There's not been any testimony here today that this was intentional. And at best, at 2.5 hours, he leaked, and I'm saying 2.5, he said 2, he leaked out about 210 gallons of water based upon his usage. I understand 210 gallons of water a lot. It's not enough to fill a swimming pool. That's 660,000 gallons in your backyard pool, Judge. 660,000. We're talking about 2 gallons of water here. I'm sorry, but I don't think that fining him is appropriate, and I don't think this was done intentionally. I think the code provides for unintentional spills. I mean, are we saying that there's never been an unintentional spill? No, what we're saying is you have a responsibility when it's your unintentional spill, you have a responsibility to remediate it immediately. And that's what he did. So I would ask that you don't find there's a violation.
I am ready for my ruling. I hereby find that based on the evidence presented, the violation as stated in the notice of violation did exist. However, I am finding that that it was not intentional. Based on the documents presented, there was a plumber that was dispatched to the property on May 7th to address what appears to be a sewer line blockage. However, in reference to the pumping out of the grease trap and the pressure washing that was referenced as being the culprit of the individuals being near the drain line with the brooms, I don't find that credible, and I'm basing that on the invoice from Grease Trap Solutions. It includes pressure washing having occurred on 5/27/2020, which is 20 days after the citation occurred. However, based on the fact that it was not intentional, I am not going to impose fines, but I am going to include the full cost of the invoice from Mitchell Stark in Construction in the amount of $13,097. I'm going to do this without prejudice, so I'm going to go ahead and allow you leave to go ahead and review the documents and come back and do a cross-examination if you wish in reference to the amounts, okay?
Yes, ma'am.
I am going to not fine them because, again, not intentional. Sometimes things do happen, but based on the evidence presented, I find that the work that was done was directly related to the accidental discharge. But I also do understand that you have a right to go ahead and contest the amount, and I'm giving you that right by doing it without prejudice. I'm not going to order fees and costs on this one, just the invoice amount, as it sounds like it was an unfortunate accident.
Your Honor. Will that be codified somewhere and sent to me, Judge?
I'm sorry, what?
Will that be codified somewhere and then sent to me as an order?
Yes, as an order, absolutely. I'm just making you responsible for the cost.
Understood, Your Honor.
Okay, next on the agenda is number 10, the property owner's White Sands Properties of Fort Myers Beach. This is a violation regarding work without permit for the installation of pavers. The case number CE 20-0619. The code officer presenting this case is Code Officer Bill Stout.
Officer Stout, can you please state your name for the record?
William Roger Stout.
Are you employed by the town of Fort Myers Beach?
Yes, I am.
What capacity?
Code enforcement officer.
At capacity, are you familiar with the property located at 2520 Cottage Avenue that is subject of case number CE 20-0619?
Yes, I am.
Please tell the special magistrate how you are so familiar.
I patrol the area of the town on a regular basis, and so I'm very familiar with that area and Cottage.
And during the course of your travels in that area, did you observe any violation of the town code?
Yes, I went by there, as we normally do, looking for any, sometimes looking for violations, and just talking to people of the town. And I noticed that there seemed to be some activity going on, and I checked immediately on my phone application to see if there was any permits pulled for the work that was going on, and there were no permits in process.
Your Honor, just for the record, next case is the same property, same violation, but a different aspect of work that was done on the property without benefit of permit. I don't know if you want to hear both cases.
Let's do one at a time, but I appreciate that. That way, when we do the second one, it'll go faster because I will have be already oriented.
Did I'm sorry, your testimony was that you determined that there were no active permits for this particular piece of property and the activity that was taking place. Is that correct?
Yes, I saw pavers being installed, and many pavers had already been installed. I believe that's the case one, the paver case.
That's correct.
Just want to double check.
And is that does that type of work require a permit under the town code?
Yes, installation of pavers on removal, even if it has a previous installed surface, you'll need a permit to remove, demolish the old surface and reinstall a new surface.
You have an occasion to make contact with the property owner and explain to him or her the situation and that there was a ongoing code violation.
When I arrived on site, there was not any workers present. I just went ahead with our standard procedure of opening a case, taking the appropriate pictures, and then notifying them with an open case. At a property, and it was mailed, certified mailed, and posted on a town site.
You had, at any point in time prior to today's hearing, an opportunity to speak to the property owner or someone associated with the work that was that took place at the property.
I've had many conversations with Mr. and the worker who was doing the work. Name's Bill. I'm not sure of his last name. He does a lot of paving on Iron Beach.
Officer Stout, let me ask the obvious question. What's the compliance here?
Compliance is, it's within, as my notice of violation states, apply for the permit for the work that you're doing. That's pretty simple.
And this work arguably would be permittable?
Yes, very much so.
Do the photographs that are in the file accurately reflect the condition of the property at the time that you took the photographs?
Yes, yes.
That photograph shows the paperwork taking place that you testified to?
Yes, yes, it does. See those behind you there, gentlemen.
As of today's date, has any permit application been submitted for this work?
To my knowledge.
Nothing further.
Let's hear from the respondent, property owner.
Yes, I am Bill Bronsard. I own a 20 years, so resident. I was hired by Mr. Schmidt to put a patio walkway on the side of his house. There was already an existing patio and walkway. A new put in, so we pulled up those pavers and built a small patio. I've done hundreds of these small jobs, not requiring by the town anything under 500 square feet of additional surface require a permit for the town. So a small walkway, somebody wants to put 10 feet on the side of it, you don't have to go through a permit process to widen a walkway. All projects. This forever, this is how, we understood it. We actually reduced the impervious area on that property. Had a patio that was about 600 square feet and had a 300-foot walkway. Made the walkway about 150 feet. The patio footprint about the same as already pavers. All we did was pull up the old pavers, and we put the new pavers. Even in the permit application, it doesn't state anywhere that a permit for a patio that is already existing with the like material requires a permit. A new patio would, if there was grass or another surface there, require, a permit to be submitted, but already an existing. Build up that patio and put that we've, and a lot of these where people want to add on little grill areas and 2 feet here and there, and that's not, that's not a permitted item. It's been told me through the town over 20 years of doing this, we pulled permits for driveways and parking lots and stuff like that, but a little area like that in between 2 houses where somebody wants to set their grill that's already a paver patio, I don't know what permit would be required. There's not a patio resurface permit, a retrofit permit. There's only a new permit application for patio. That would be a new site area, nothing that was there like product, maybe grass that you're transforming. I could see a permit being pulled, but pulling up, one product, putting the same product down, same footprint, actually reducing the impervious surface property. So.
The town addressed the issue regarding the requirement of a permit, even though it's a small area?
Your Honor, yeah, I don't mean to words in the witness's mouth, but I understood him say that the exception, the permit was if you're adding on up to 500 square feet of additional space. What we have here is a complete removal, according to his own testimony. Not adding on, they demolished the existing patio and installed a new one. His own testimony, under that situation, permit is required for a new patio.
Let me ask you this, how is that any different? The 500 square foot rule, if we had a 700 square foot patio, we can add 100 square feet to that patio under the 500 square foot allowance, but we can't reduce the size of that patio.
I don't believe that was the testimony. It's not regarding the reduction, it's regarding the replacement. He actually did state it in the earlier, I wanted just for him to repeat it, regarding the replacement of one material for the other. Is that specifically stated in the city code, the town's code?
And I'm not that familiar with the code to give that answer right now.
Okay.
We were given a non-permit for already pavers there though.
Yeah, and again, I think
have
that's.
a survey showing that all the existing areas that were already paved compared to what we did, actually did a reduction on the size of what we put in. Actually a smaller patio of a smaller size of the exact same product that was there. Never been required for that. That's why you guys have a 500 square foot under rule. All an additional square footage onto a job without getting a permit. This kind of falls under that same.
All due respect, no,
Don't
it does
think
not.
it does.
Yeah.
I don't think it does. They're apples and oranges. And I'm looking at the pictures and it looks like there was some, is the demo part of this case or the other case?
No, the lack of a permit is for everything. So-
Remember that there's a reason that I ask questions. Is the demo part of this
Yes.
case or the other
Yes,
case?
it is.
Okay. It sounds like there was removal of slab and removal of dirt. Go ahead
No,
and.
there was just pavers and there was a concrete walkway.
And you addressed the concrete walkway? Okay,
Outside the house, concrete with.
okay. That, to me, that looks like something that would fall within the permit requirement, if anything else, that right there. Then what's the issue? I guess you just don't want to, your client just doesn't want to pay the permit fee?
Well, it's not the permit fee, it was just a matter of, addressing this
Okay.
500 square foot issue, We were offered to reduce the size of the patio and reduce the size of the walkway to be under that 500 square foot threshold. My client, and he doesn't want to reduce the size of his.
Nobody's asking you to do that. They're
That's
just
why I
saying,
got-
just
I got an
pull.
email from Daphne that said, as you know, the code states that over 500 square feet of pavers requires a permit. This here, it has not been removed by Thursday, the town will require an immediate daily fine. If the additional square footage has not been removed by Thursday. What she's saying is she's allowing the 500 square feet, but anything over
Well,
that
I'm
has to
gonna.
be removed.
Right, so, and you were given the option of doing the after the fact, correct? Never an option?
But what we're doing is
No, answer my question. Was that an option given to you?
there was an option given to us
Okay,
yesterday.
so typically, if you've been in the business for a long time in construction, if you have a code violation, you have two choices. Either you complied with the code, and if it was something illegally placed, you remove it. So the options were there. She was just giving you options. In fact, it wasn't a matter of telling you to remove it. Besides the fact that at the end of the day, she's just trying to keep you from having to come here today, but here you are today. So I'll address it for you. All right. I hereby find that the violations as stated in the notice of violation did exist. Ordering the property owner 7 days to submit the permit application, 21 days for the issuance of the permit, or $250 per day until the permit is issued. I'm also granting the town's request for the $75 in fees and cost as incurred by the town in bringing this matter before the magistrate. Compliance, however, may mean the after-the-fact permit or removal. I'm not going to tell you what you want to do, you're going to do with your property. I'm giving you the options of what the code allows, either the after-the-fact permit, which probably the easiest thing to do, or removal. Okay, so long as, especially the after-the-fact permit, which is probably the way you want to go, but again, I'm not going to tell you which route to take. You have a little bit of time to go ahead and get it done, and no, there will be no fines. But I do have the 75 in fees and cost assessed with payment within 10 days.
Question, if I could, please.
Oh, yes, go ahead. Your name?
Jesse Schmid.
Okay.
How long does the town get to review this? How many times do they get to send it back and we get to resend it back in for submittals? Because our permitting process has not been,
Here's the way that I do it.
I'll be more happy to submit a permit, but the problem is, it will never get issued because they'll keep sending it back time after time after time, and then they have 2 weeks to submit it again, and there's no way I can be under your timeline.
And I understand there's sometimes things are within your control and things that are not, and that's why I always say, so long as you're moving forward and get into compliance and you stay in touch with the city will work with you. The city has the authority to go ahead and say, listen, this is taking a little longer.
For $250 a day, they will, yes.
The city will go and say, listen, you need additional time, so long as you're moving along. The problem is when the town is completely ignored. That's where the homeowner runs into issues, thinking that they didn't do anything wrong. So long as you're cooperating and you're submitting and you're taking care of it, you're pushing it forward, things happen. Give the town a prize, and they'll work with you regarding more time.
So you're telling me that, I mean, if I have a case and I'm actively working on it, they can't start fines if I'm actively working on it.
At the end of the day, right now what is going to be, it's the order telling you what to do. Before that ever becomes like done and done as a fine or a lien, it has to come to me again. Let's say, for example, something happens and it comes back to me again, saying, hey, didn't comply with the order and he didn't do it within the time frame. You can come back and say, well, here is my evidence that I was moving it forward and things outside of my control happened. Those are things that I'll consider and say, okay, maybe he needs additional time to do this, or he's in compliance, or whatever. But you've got to go ahead and be able to both show to me, to the town and myself, if that would get to that point, that you were moving expeditiously. I have a feeling that I won't see you here again. I have a feeling you'll comply with it in a timely fashion, and this will be it for you, okay?
Mr. Magistrate, if I may make a suggestion in that regard, if you wish, staff will make sure that we put this on as a status update at the next meeting in case the property owner needs additional time.
That's up to him. Yeah, we can put it on the agenda as a request for extension of time. I think it's premature, to be honest with you, but if you're that concerned about it, we can put you on the next agenda. And then if you need it, you're already got a slot to ask for more time.
Yes, I am very concerned that I will not have a permit.
Okay, so let's go ahead and just add him I will put it as a status. If you're complied with, then it gets removed from the agenda. But if you have issues along the way, come back, let me know what's going on.
We will advise the special magistrate if the town has completed its side and it's the property owner who's not.
Correct, and that's why I
following
say that things happen, and I hold the town as accountable as I hold the property owner. That's why I do it that way in regards to, hey, listen, if so long as you can show me, hey, it wasn't me, I have to take that into consideration. Okay? Thank you, good luck to you.
Thank you.
I got one more.
We have
We
one
got
more.
one more.
Unfortunately.
We have the-
There's number 11 is going to be the same, same property
Tiki hut,
owner
yeah.
that we've seen before here. This is going to be another work without permit, the Tiki Hut, the code case number CE 200623. The code officer is Bill Stout.
Mr. Magistrate, as staff has indicated, Officer Stout you've been sworn in, correct?
Yes, sir.
And you are employed by the town as a code compliance officer?
Yes, sir.
In that capacity, you're responsible for enforcing the town's codes and ordinances?
Yes, sir.
Are you familiar with property at 2520 Cottage Avenue that is the subject of case CE 200623 here this afternoon?
Yes, I am.
I believe that your previous testimony to get to the point was this involves a tiki structure that was placed without any review or issuance of any permits. Is that correct?
Yes, sir.
You take photographs of the violation?
Yes, I did.
Are they in the file?
Yes, they are.
Do they accurately and correctly reflect the condition of the property in the time that you took the photographs?
Yes, sir.
Has the property owner applied for or come in or brought any drawings for staff to review?
Not to my knowledge as of today.
As of today. Is that all that needs to be done to bring the property into compliance?
Yes, sir.
Further?
I do have one question. Is it possible to bring it into compliance? Is there going to be an issue with any setbacks or anything like that, or am I crossing the bridge before I get
It
to it?
could be, but we won't know that until we receive the site plan and the permit. I mean, I don't know. I mean, we haven't received anything that would prompt us to go and check the setbacks.
Sometimes the code officers are able to tell just from experience, this is not going to make it, or versus.
I guess what,
I'll tell you in a second. Yeah, go ahead and tell me, because I think he's done. I'm done with his questions.
I just didn't understand what Daphne's talking about. There's no permit for this, is that correct?
He said that it was built without a permit, yes.
Okay, but she said there's no permit in for this, correct?
As he said that their last review, there was no permit application and no
Okay, the
permit.
permit was sent in on 10/26.
Do you have a copy of the permit?
I can get one real fast, yes.
Yeah, okay. You said the permit application was on 10/26, or what, the
Yes.
after the fact permit
After the fact permit was sent in on 10/26.
was issued?
It wasn't issued, it was sent in on 10/26 and it's never been reviewed, as
Submitted.
far as I know.
Right, you applied for it.
Yes, we
I
sent in for the
checked this
permit.
morning we don't have anything. So there's no permit. Normally, when we get a complete application, that's when we issue a permit number. Then we review it. So if we didn't receive a complete application, it would not be given a permit number in our system.
But he could have applied, just not reflected in your system, is that what you're telling me?
If it is not reflected in my system, that means we did not receive a complete
It
application.
doesn't mean that you didn't receive anything.
That is correct. It would have been sent back.
Okay,
And I checked this morning and there was nothing.
Is there a notation in the system regarding what his next step is to be able to get that permit issued?
What happens is if he submits the permit, the application, then it would go to our permit techs. If it is not complete, then they send it back. We don't even give it a permit number so possibly through an email, there would be, but that's not the system that I checked this morning.
And I understand that. It's like I understand when it goes to the review process of the permit, they might have some questions or need additional information. Normally, in this case, I'm suspecting it'll be some engineering drawings. But hey, I'm not getting there yet.
What
We're not
I'm
crossing that
saying
bridge.
is if
But
they-
normally, hold on, but normally the building department will reach out to the property owner and say, hey, listen, you're missing this. Is that the stage we're in?
It appears to be. I don't know because all I went to look to see if there was a permit application that was in our system, and there was no permit application in our system.
Okay, and your testimony is that you applied for it. Where are you at in your understanding regarding where you are in the process?
I was waiting for the letter from the Seminoles, because it's a Seminole-built tiki, which
Okay.
was turned in also.
But let me go ahead and how do I do this?
I'm trying to get it.
Do
for
you
everybody.
understand that you're gonna need the permit? Sounds like you do because you applied for it.
Yeah, and that's why I wish Steve was here with
Okay,
me.
so do you understand that there is no exception to the permit requirement because it is a Seminole tiki hut? Are some property owners that get confused about that?
Yeah, that's correct. And then they told me, since, even if it's Seminole built, I still have to have a permit.
Correct.
So that's why the permit was sitting out on 10/26. And
Correct.
I was trying to bring it up to see if I could find it here, but my phone's not.
There's documentation that was requested by the town for you to provide to them to keep the
I can
process
provide
moving?
documentation where it was sent in, yes, for sure, 100%.
Okay, so based on
Where
what
it
the
was sent
town
in on
requested?
10/26. The permit was sent in, yes.
No, based on what the town requested, did you comply with their request of what they needed to keep the permit process going? Apply for the
As
permit.
far as I know, yes.
Okay. This
I'm
one,
not the one that did the permit. Sutter Builders out of Naples is the gentleman that did the permit.
oh, okay, so you're not handling that yourself.
No, Sutter Builders
Okay.
is the gentleman that did it.
Here is my inclination, and I think this is where the town is going. It's gonna be a similar order to the one we had before, where I'm gonna give you time to go ahead and apply for the permit, and a certain amount of time to go ahead and get it issued. In your case, it sounds like you already applied for it, so you just gotta go ahead and stay on top of it, find out what they need to get it to issuance, okay? So it's gonna be your responsibility to make sure that you're pressing your contractor, or you yourself is providing the town what they need to issue that permit, okay?
And likewise with the town.
Correct,
to be
same,
transparent,
yeah.
and they need to, hey, Mr. Schmid.
You need this or that, or, yeah.
Sure. One thing I would like to address, if we could, I mean, we're talking about permits and these two permits here. Whenever we submit for a permit and they send back a resubmittal, can't they put every item they need the first time?
That's outside of my,
So, okay,
that's outside of my purview here.
Sure.
Okay,
Well, it speeds the process up so much.
they're trying to do the best they can under the circumstances. I know the system has improved tremendously in the last year or so, and I'm sure they're doing what they can to go
Madam
ahead and do it.
Magistrate, if I may, and I would like to, maybe if we could revise your previous order regarding the same property. I think you stated that 7 days to submit the permit application. I would suggest that it would be 7 days to submit a complete permit application.
I'm not inclined to do that just because there are things that happen that are outside the property owner's control, and sometimes if he's in need of engineering drawings, sometimes even the act of retaining the engineer can be a problem. We just want them moving along.
We do understand Thanksgiving is next week.
But you should be, again, like I said, I just want to see you moving along. That's all. So you have a responsibility, the town has a responsibility
You
too.
want to send emails and you want a paper trail of it.
I want a paper trail that you're doing everything you need to do on your end.
Exactly, yes.
The town is gonna do what they need to do on their end, and again, hopefully I will see you again after this.
Agree. Sounds
Okay.
great.
I hereby find that the violation as stated in the notice of violation did exist and continues to exist. I'm hereby ordering the property owner to submit for the permit application in 7 days, and then 21 days thereafter for issuance of the permit, or face $250 per day until the permit is issued. We're gonna go ahead, since we're adding a status meeting on that
That's
other
going to be a
one.
little, because our next agenda's not going to, our next hearing's not going to be until February. So theoretically, what you've done is just given him until February to comply with this order.
Okay, so we'll go ahead and do it till February. That one might take you a little bit longer than the paper one. Okay, so I'll revise it till the February meeting. Should be done by then. All right, and the town is requesting the 75 fees and cost. I'm granting the request for the 75 fees and cost. That one you're not saving yourself from, to be paid within 10 days. Okay,
When can I pick a copy of this up to get?
you're gonna get an
Okay. It'll be
for
mailed,
both, one for each case.
it'll be mailed to me then, or? Okay, thank you.
Thank you.
All right, Madam Magistrate, number 15 on our agenda, Sugar Beach Estate. The violation is the destruction of dune vegetation, violation of LDC Section 14.3A3. The code officer presenting this case is Chad Schutz. The case number is CE 20-0695.
Officer Schutz, can you please state your full name for the record?
Yes, sir, Chad Schutz, I haven't been sworn in yet.
Do you swear affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Are you employed by the town of Fort Myers Beach?
Yes, sir.
What capacity?
Environmental code officer.
Are you familiar with the property located at, 5286 Estero Boulevard that is the subject of this code case CE 200695?
Yes, sir.
Please tell the special magistrate how you're familiar with the property.
Let me grab my files. So I observed that the dune vegetation had been really cut down to the substrate and defoliated, meaning that it was brown and yellow, in late September of 2020.
Did you inspect the property?
Yes, I did.
What did your inspection show?
That the dune vegetation had been severely cut back down to the substrate, defoliated,
Explain for the unfamiliar, when you say cut down to the substrate, what do you mean? Was it cut down to the ground? Was it cut down halfway? You know, can you illustrate what the violation is?
So if it's whatever vegetation was there was it looked like it was whippersnippered down so that there was no leaves or foliage, just a stem and roots left underneath.
Did you take photographs of the property when you inspected?
Yes, sir.
Are the photographs in the file?
Yes, sir.
Do those photographs accurately and correctly reflect the condition of the property on the date that you visited the property and took the photographs?
Yes, sir.
Do they show the defoliation and cutting that you testified to?
Yes, sir.
Is such activity permitted?
No, sir.
Why?
Because whenever you cut plants like this, they tend to not survive.
Those type of vegetation protected because they're part of the dune system?
Yeah, so dune vegetation specifically is protected by the code, and while you could trim up to maybe 25% per ANSI 300 standards to allow for the plant to survive but still trim it, cutting all the foliage off. Alteration.
Permit is required for that? Or any other activity?
Yeah, it would be if permitted by the FDEP.
Are you aware of any permits having been issued by either the town or any other agency for the activity that took place?
No, sir.
Anything further?
I do have a question. Were you were the one who were present at the property, correct?
Right.
Personally were at the property, correct?
Yes, ma'am.
Were you able to visibly see that it was cuttings as opposed to an act of God, for lack of a better word?
It was definitely anthropogenic.
Okay, so it's definitely a cutting.
Yes.
Okay, all right. Get your name and relation to the case, please.
Michael Drake. I'm a property manager.
Thank you, Olive.
My name's Michael Drake.
Okay.
I'm part of staff of Sump House Vacations. We manage the property for the owner. On that day, we actually responded, and we did see that it was pretty clear that it was cut by a weed eater, but nobody from our staff or the owner told the landscaper to do this. We actually spoke to the landscaper, and he is denying it, and he and he's denying it, and we also had asked him to put together a restoration plan for us. And weeks go by, nothing, he didn't get back to us. So we, the owner and us, we were actually going with a different landscaper.
Okay.
And he's putting together a restoration plan for us, and I'm actually asking for another 30 days, this restoration plan done. And if we, because we did not, tell the landscaper to do this, we were asking for the fines to be waived.
Okay, so, here's what I'm seeing. Because this is going to be through the Florida Department, of the FDEP. The FDEP is going to have, it's going to have to go, right, through the plan, not just through the town, it has to go through FDEP.
I'll be in correspondence with them.
So, that right there means your process is going to be a little more complicated than you're actually even thinking it's going to be.
Okay.
You're not going to be now dealing with the local town, with the town environmental division. You also have now to get, because it's dune and it's protected, you're going to have to deal with the
Your
Florida
Honor,
Department.
Sorry to interrupt you. So if they're just planting dune vegetation, technically that is an exempt activity. So it may be possible that would not have to go through.
Restoration
process.
plan would have to come to the town, but not through the FDEP.
But it's
The
not
permit
ex-
would need to,
It's not as extensive enough for it to have to go through the state.
Right.
yes.
Okay, so guys, that was my concern, because I've
I
had it
understand.
before where it's massive amount of issues and it goes into a black hole.
As long as we're not, excavating or moving dirt around, which they should not need to,
Okay,
not be.
it's just a matter of the replanting only.
ma'am.
Okay, and is the planting material readily available for a landscaper too?
There's several nurseries in the area that could supply the plants needed.
Okay, well,
The
that's,
issue was the prior landscaper, trying to get him to do it.
you're gonna have time to do it. I'm gonna give you time to do it. I'm just trying to figure out what steps you're gonna have to take so that I can know how much time to give you.
Okay.
Your Honor,
that's
what
I'm
the
trying
town is
to-
asking for certainly is the fine of $1,000, which was noted on the citation, but we asked for the restoration plan to be submitted within 30 days and then implemented within 60 days. So I feel we've given ample amount of time.
Again, that's the reason that I asked
Yes.
those questions, because if it has to go through the state, it's
Yeah,
gonna be a different
exactly.
monster. Okay. All right, based on that, I'm ready for my ruling. I hereby find that the violations as stated in the notice of violation did exist. And as such, I'm ordering the property owner to submit a restoration plan within 30 days to the town, and for the work be restored, for the dunes to be restored and the plans to be restored within 60 days. Otherwise, face a fine of $250 a day until the violation is corrected. I'm also granting the town's request, amount of $75 for fees and costs incurred in bringing this matter before the magistrate. I am imposing the requested one-time fine of $1,000 on the basis that the damage that was done is to a large extent irreparable and irreversible, and right now all that can be done is mediation type of process in order
That's
to get
fine.
it to its point.
Is it per property? System.
Well, right now, you're just cited in one property.
No, we
No,
have, the
wait.
next case is the
case is the-
exact same thing
Oh,
for the
okay,
neighboring
so
property.
this is only for this one case?
Yes. Next case is the exact same issue, just for a different property.
Oh, yeah, so it's gonna be by property. Okay, so that's the one. And again, just like I've told everybody else, just so long as you're moving along, he will help you in terms of getting the town, and if there's any issues, I'm sure it'll be brought up to my attention if there's more time warranted. All right, so this one, I want to go ahead and also do a status callback just because of the environmental nature of it.
Again, that's not going to be until February.
That's fine.
Okay.
To the extent that the property owner is amenable to agreeing that a violation occurred, we would be willing to have the same compliance action ordered by the special magistrate in the next case.
That's up to him if he wants to stipulate to it.
Wait,
So which case was that first one?
5286. The second one that we're coming up on is 5276.
Okay.
Basically, the same thing would apply to it.
It's a dune, it's basically one dune, but when it was inspected, it shows that the landscaper, just went in the first property and not so much on the other one, and all that's basically started to regrow already over in front of that other property.
The problem is that until it is back into full compliance and into full compliance, the code, it's still out there. It still exists. You want us to go through the whole case again, or do you just want to?
That's fine.
Same thing? Okay,
Same thing.
Based on the agreement by the parties, the same order as in the previous case will apply to this case number
200696.
200696. And just post it. I might have I'm going to request for a status update on it, just because on these environmental ones, I like to keep a close leash on them and make sure that they're moving along. There might be a chance that you're done by then, and that might never happen. You might never have to come back, but just in case, I just want to make sure that these are moving along and we're getting the beach back to where it needs to be. Okay?
All right, Madam Magistrate, that brings us to number 18. This is Oceanic Blue Retreats. The violation is trash placed at curb more than 24 hours prior to pickup. This was a citation that was issued by Code Officer Bill Stout. The case number is CE 20-0506.
Officer Stout, you've been sworn in, correct?
Yes, sir.
And you are employed by the town of Fort Myers Beach as a code compliance officer?
I am.
You're, in that capacity, you're responsible for enforcing the town's codes and ordinances?
Yes, sir.
Are you familiar with the property at 61 Flamingo Street that is
Yes, I
the
am.
subject of case number CE 20-0506?
Yes, I am.
How are you familiar?
It's just, just one of the houses you see, and I go there. Very nice place.
Did you receive a complaint regarding this particular piece of property?
Yes, I did.
What was the complaint?
Trash containers were out prior, more than 24 hours prior to pickup.
Is that, there a time restriction in the town code that says you can't do that?
Yes, there is.
Did you have occasion to issue a notice of violation or a citation to the property owner for the violation in question?
What I did, sir, was give them a warning, which is our typical. We give them a warning, letting them know that this happened, and inform them that if it occurs again, then we will possibly assess a fine and a dollar amount.
That happened?
We removed those, and then approximately 2 weeks later, I received another complaint.
What?
Trash containers were again out there. Also, at that time, there were other properties that also the people complained about. I issued 2 warnings for those properties as well.
Respect to this particular piece of property, this particular code case, did you at that point in time issue either a notice of violation or citation to the property owner?
Yes, I did.
That in the file?
Yes, it is.
Did you take any photographs of the property to document the violation in question?
Yes.
Are they in the file?
Yes, they are.
Those photographs accurately and correctly reflect the condition of the property at the time that you took them?
Yes.
Any contact with the property owner or the operator of the property?
Last week, the property owner contacted me via email, requesting some information about the case. I complied and sent her pictures of the case and pictures of the citations, and I did not receive any of the reply from I sent them.
Obviously, other than continuing to not to violate the 24-hour max placing, is the only thing that is otherwise required to comply with this case is pay the citation?
Exactly.
Do we have anybody here on behalf of the property owner? I hereby find that the violation as stated in the notice in the citation did exist, and that proper warning was given, and it was ignored. I hereby issue a one-time fine of the $100 pursuant to the citation, and set $75 in fees and cost incurred by the town in bringing this matter before the magistrate, payable within 10 days. Okay.
All right, Your Honor, as you can see on number 19, they came into compliance. We're moved on to number 20. This is with Terrence, Brelge. The violation is work without permit, the low flood elevation, the bottom floor enclosure. It's case number CE 20-0096 with our code officer, certified floodplain manager, Steve Wick, presenting the case.
Say that several years back, saying Mr. Wick really meant nothing, but now it has a whole different connotation.
We joke about it all the time.
Mr. Wick.
Yes.
Mr. Wigg, you don't hurt my dog.
You've been previously sworn in.
Correct.
And you are a code compliance, a code enforcement officer for the town of Fort Myers Beach, is that correct?
Yes, sir.
And you are particularly responsible for enforcing the town's floodplain regulations?
That is correct.
Are you familiar with the property at 61 Flamingo Street, I take that back, 185 Pearl Street?
I am.
That's case number CE 20-0096.
Correct.
Tell us about it. What's going on?
The town received an anonymous complaint about work that was occurring, and it was involving the closing in of an elevated home. After investigating the matter and having taken some pictures, which are in the file, determined that a permit had not been secured before such work had begun and opened up a case. Let me mention that, Your Honor, that this gentleman has been communicative with the town. We've been trying to work with him. He's been an honest effort. I think he's had some trouble with his engineering firm. The only reason we're here is it's just taken such a long time since the original of this case that I felt it prudent and in the town's best interest to come to a head.
What is the nature of the, let me rephrase that. Obviously you've made contact with the property owner. Did you issue notice of violation in this case?
I did, sir.
And did you also issue a notice of hearing for today's hearing?
I did, sir.
There's copies of those documents in the file.
Yes, sir.
Without going into too much detail, can you explain to the special magistrate why this is an important issue, the nature of this violation?
In brief, when you enclose underneath a home, if you don't do so in a fashion that will alleviate floodwater, should the home get flooded, it can jeopardize the overlying structure and life above. And it also, from the building perspective, we don't want building materials to fly away in a storm.
And is it also important for the town to review this type of work? Because as I understand it, under the National Flood Insurance Program, that downstairs area can't be finished out. It's to be habitable space.
So that's correct.
And the only way to ascertain that and make sure that the structure and by way the town is compliant with the National Flood Insurance Program is to the construction activity.
That is correct, via permit application.
Further.
I think I do have a quick question. It sounds like you implied that it is habitable?
Oh, ma'am, I think he was just asking a general question. In this instance, it's not a habitable space. But oftentimes, we need to go through the review process via the permitting application in order to substantiate whether it is or is not.
Okay. So at least to your knowledge right now, there's no interior finishes or
Oh, ma'am, in
electrical?
fact, the back of if I'm correct, sir, the back of the house is not even finished. It's not even enclosed, but I can't go on the property to see the back of the house. So my first thought was the whole thing was enclosed. And he's been very compliant from that perspective.
All right.
I brought
Go
you
ahead.
pictures.
Say your name. Say your name.
Terry Brellia.
Okay. You're the owner of the property, correct?
Or Terrence,
Okay.
I guess, yes.
All right. So what happened with this enclosure?
Just to go back a little further, I bought the house in 2017 and it needed a little bit of upgrade. And I am no way trying to get away with anything because I have applied for 3 permits on this property already and have gone through the process, done the work myself, got all the inspections and everything went well. My understanding when I applied for my last permit that siding was not a permittable thing. I didn't delve enough into it to find out upstairs, downstairs, what the things were. There's a storage room downstairs, and it was rotted out. I tore it out, and I replaced the siding, for lack of a better term, and the walls on there, and so that's when I got them first. I worked with Steve. I have 0 complaints. We have a good relationship. He worked with me through the process, told me what I needed to do. I was a little disappointed that I had to do it after the fact. If anyone from the county, when they're inspecting my last job, would have said, no, you need to do this, they finaled it because they wanted it out of their hair. And they said, and I said, well, I'm not even done yet. Like, well, if I would have finished the siding during that process, I probably would have never had an issue. Worked with Steve. I applied for a permit after the fact. I got some corrections that he asked for me to do. No problem with those. We worked through that. I got a letter from an email from Robert Borchert in end of June, and about things that he needed on the plans. I tried to get a hold of Robert for 5 weeks, never got a return. I finally called who I thought was someone who was of Robert to say, hey, what's going on here? I don't know anything. Found out he's no longer with the city. Signed to somebody else. Jack, again, worked with me, tried to get this done, gave me names of engineers. You made a comment on the last case, how hard it is to get an engineer down here. 17 engineers before I finally got someone to call me back. Worked with him, not engineers, emails and phone calls to different engineers. Finally got someone to call me back. Got someone who would help me through the thing. Talked to Jack. Jack said the engineer what he needed. The engineer said he would help me. David Easterbrook, guess he's known in the area or whatever. David had to have some cancer surgery. Long story. Wife left him or something. I'm off the record. He had a tough time. He had a tough time.
There's a country music song there.
Disappeared for almost 2 months on me. I finally got the plans from him last week.
Okay.
I submitted the plans to Jack last week, Tuesday.
Because I haven't heard back from Jack.
And I haven't heard back from
Okay,
Jack.
that might actually be good.
Okay. So, all I'm saying is I'm trying to get this resolved. I know it has taken a long time. The first 2 delays, I won't take those upon me. Those were the world came to an end, and then there were other issues going on. But it's a pretty simple fact. It's non-habitable space. I get it. There's a difference between above and down now. There's nothing that Jack or Steve told me that I can't fix. I just need time.
Okay.
To fix them.
You concur with that statement?
Absolutely,
that it's-
100%.
Okay. Because my first concern was, is it permittable in the first place?
No, we wouldn't even be here, Your Honor, unless it's just been so long that it was time to
okay,
bring this
so
to a conclusion, or attempt to bring it to a conclusion.
Doable, okay. All right, so based on that and how cooperative the homeowner has been, what is the town requesting?
At this time, Your Honor, I mean, I would say 60 days. I think Steve and I discussed 30 days. Is that what we discussed? For the issuance of the permit. As far as it is my understanding that once this last piece of it is done, the permit will be issued. It's just taken, it's March to get this one piece, or I'm sorry, May, to get this one piece taken care of. So 30 days for issuance of the permit, and then if not, $250 standard, $250 per day, 75 admin to be paid within 10 days.
Okay. I hereby find that the violation as stated in the notice of violation did exist and continues to exist. I'm hereby ordering the property owner to obtain the permit within 30 days. Otherwise, face a fine of $250 per day So the violation is corrected, and I'm also granting the town's request in the amount of $75 for fees and costs incurred by the town in bringing this matter before the magistrate. Like with the other people, if there's any issues, just bring it to their attention. It might come back to me. Just so long as you have it documented.
Get it.
Good luck to you. Was there any work that needed to get done other than the permit? Once the permit's done, it's over? Or is there work that's going to be?
I think you have work to do, right?
Yeah, once I got the notice of violation, I put
Okay.
the exterior up, but I didn't do any of the interior of the wall.
And
I left it.
that one, just so that you know, based on the citation you got, it's just the issuance of the permit.
Yeah,
So that was a step forward, just trying to
Oh,
back, things that I want to be able to have in my head. I have to go
my
back for more time or
understanding was
something.
Once they issue the permit though, then this part of it's done.
That's correct.
Yeah, this part of it, once you get the permit, it's over. You don't have, this order is not about you getting the word corrected, it's just the permit. Okay? All right, great. Next case?
Okay, Your Honor, we're
Up to
on 21, I'm sorry?
Can we maybe take a 5-minute break?
I will concur to that.
Okay.
How many, and 5 minutes, because we still have people in the audience.
Yeah, I know.
Let's make it quick.
I think we only have 3 more.
All right, we're gonna take a 5-minute recess, if not shorter.
Yeah, let's give it. Sign away. Fumbling through all your
I know
shit.
that, and I'm just-
I mean, he's just, what a fucking asshole. Number 21 on the agenda has been brought into compliance. Number 22, property owner is Trayvon. This is regarding the registry of short-term rentals. The violation is the unregistered short-term rental. Case number CE 200645. Presenting the case is our short-term rental coordinator, Kristen Schumacher.
Schumacher. Nice to see you again.
Hi.
You are employed by the town of Fort Myers Beach, that's correct?
Yes.
And previously sworn in as well? You are the town's short-term rental coordinator?
Yes.
And in that capacity, are you responsible for enforcing the town's rental regulations, including registration?
Yes.
Are you familiar with the property located at 8300 East Estero Boulevard, unit number 101, that is the subject to case number CE 200645? Please explain to the special magistrate how you are familiar with this property in this case.
I discovered an online rental ad for 8300 Estero Boulevard, Unit 101. I've included in the packet 2 of the rental ads, the back, along with the property identification. On the rental ads, it even shows that there's bookings. So I went ahead and sent a notice of violation, notice of hearing.
Let's be clear, that this is, the rentals at this location aren't necessarily prohibited. It's just in order to be able to do that, in order to operate them legally, they need to register with the town.
Yes.
Did you have any contact with the owner or operator of the short-term rental?
No.
Did you attempt to?
Just by the address, that's the only information I had, by their address recorded in Lee County Property Appraiser Office.
There's no other information available to contact the property owner?
No.
And notice of violation or citation and notice of hearing issued in this case?
Yes.
Are they in the file?
Yes.
Had, after either the notice of hearing, any contact with the property owner?
No.
And as I said before, these property can be brought into compliance by registering?
Correct. Yes.
Quite a difficult process?
No.
Be done pretty much online?
You can get the forms online. You can get it by mailing it in or emailing me, and we online payment.
Further.
Do we have somebody here on behalf of the property owner? It's noted that there's nobody here on behalf of the property owner. I hereby find that based on the evidence presented, the violation, as stated in the notice of violation, did exist and continues to exist. I'm hereby ordering the property owner to register the short-term rental within 5 days, otherwise face a fine of $250 a day until the violation is corrected. I'm also granting the town's request in the amount of $75 for fees and costs incurred in bringing this matter for the magistrate.
Magistrate, will your order reflect that the property owner is not to have short-term rentals until they've registered?
I can include that at the town's request. I can include that there'd be no short-term rental until the property is properly registered.
Thank you.
Okay, Your Honor, we're on to number 23, property owner Tezak, Wayne, and Helen, the trust for Tezak Family Trust. This is a violation of dune vegetation destruction, rake-in without permit, and a vehicle on the beach without permit. The code officer presenting this case is Chad Schutz, case number CE 200697.
Mr. Schutz, you've been previously sworn?
Yes, sir.
You're employed by the town of Fort Myers Beach?
Yes, sir.
In that capacity, are you responsible for enforcing the town's environmental regulations, including
regulation of dune activities in the dune area.
Yes, sir.
Are you familiar with the property located at 50 Chapel Street?
Yes, sir.
Case number CE 200697.
Yes, sir.
Explain to the special magistrate your familiarity with the property.
So I received a complaint that the property owner was asking for vegetation to be removed from his property in the dune and beach area. And on inspection, I saw that a substantial amount of sea oats had been cut at the substrate and also raked over with a vehicle and what looked like a chain link fence. And also that in the dune that's kind of partially in front of the property, but more so in front of the town access property, it looked like that vegetation had been defoliated just due to its brown nature compared to the same species of dune vegetation in the near vicinity, and the fact that it was wet season.
Is it allowed under the code to spray vegetation with beside dune vegetation in the area in question?
No, it is not.
Is it allowed for someone to cut or otherwise remove dune vegetation in the area in question without the appropriate permits?
No, it is not.
Is it allowable under the code for someone to have a private vehicle on the beach in this particular area?
Not without a permit.
Did you inspect the town's records to see if any permits had been applied for the activities in question? The raking without a permit, people on the beach, and removal of the dune vegetation?
I did.
What was the result of that inspection?
I did not see any permitting for this property within the last couple of years.
Do the photographs in question reflect the condition of the property and the date that you took the photographs?
The day that I took the photographs? Yes, sir.
With respect to, I just want to point out one of the photographs shows vehicle tire tracks. I'm assuming that's the violation of vehicle on the beach without a permit?
Yeah, you can see how the rake has gone over oats, vehicle tire tracks kind of straddling them and raking over sea oats.
Which picture is that one?
The one that says live sea oats raked over.
I have several here.
Did you make any contact with the property owner?
I sent an email to the property owner on October 7th, the email that was on record with the town.
Any follow-up communications?
No, not until late October. I have contact with him.
To inform the property owner of the need to obtain permits for the activities that took place?
No, the property owner was confrontational, and I just, instead of trying to explain things to him, just stated that I didn't have anything to say to him just because of the nature of his demeanor.
The remedial, the corrective action is obtaining a permit for the activity and
Correct. He has since obtained a raking permit and a vehicle on the beach permit, and I did meet with him to explain to him different types of vegetation and what was allowed and not allowed.
Similar to the other previous case we had, that was is the scope of the damage to the dune vegetation. Is a DEP permit going to be required, or is this just a matter of replanting?
Matter of replanting.
Anything further?
I have a quick question. In the file, we have, this aerial. Do you have a date of when that aerial was from?
Approximately January 2019, so it's Google Earth. That's the latest that was available. I realized that the dune, as with all dune systems, can change dramatically and does not accurately reflect what's out there now. If you look at the photos the other photos that I've taken, especially with the number 1 and number 2, kind of shows you more the location of that current dune that was defoliated. And then you can kind of work out relative to the property boundaries where that area of sea oats was down and others were raked over.
So what I'm trying to get to is, in this one, there's oats over here, beach oats over here, and this is like a vacuum of
Correct.
nothing there. It's just pure sand.
So if you
This
read-
is the property, correct? First of all, this is the property you're referring to, right?
Yes, ma'am.
Okay. So was that same condition regarding the sea oats the same property and then removed? Is that what you're telling me?
No, if you read the FDP email, it appears that Mr. Tezak has been raking for several years now without the benefit of state or local authorization.
Okay. Do you have knowledge as to how long it had been going on? Because again, it's a drastic difference between what's on the neighboring property to what.
I've only been working with the town, but my review of the records, it appears that it had been raked consistently with a professional raking service, and he took over several years ago, is what I'm speaking from knowledge of just
The
reading.
personal knowledge, your knowledge on what you reviewed the documents.
Just reading the emails and the interchange that were submitted to you and from his correspondence with FDEP, he took it over. It does not appear that any raking, permitting, or vehicle on the beach permitting has been obtained in the last couple of years.
You said that he has obtained one now, right? Obtained one now?
He did obtain one now, yes.
Okay. Let me go to him and then I'll come back to you. Do you have another question? Go ahead, say your name and relationship to the property.
David Tezak.
Okay.
Your magistrate, I am not the owner of the property, and I'm not a party to this complaint. However, Mrs. Tezak, for the Tezak Family Trust, requests that this citation be denied on the fact that Helen was not present at the time of these alleged violations, nor was she given her due process rights of notice under Florida law. Helen Tezak requests an extension so she can consider her legal options in defense of these alleged allegations. And this hearing, which was fast-tracked in less than 21 days from the time of the alleged violation to this hearing. And then Helen would like for this request to be entered into the record along with a signed affidavit and oath stating that she has been living in Reno, Nevada since January 29th, 2020, and has not been unable to return to Florida due to the COVID-19 pandemic at the age of 92 years and health issues that put her in a high-risk category.
Do you have anything to add in regards to the raking of the dunes or removal of vegetation?
None of that occurred. Those are false allegations. A beach is defined as the area between the high water line and the water. It's not even on the beach is what they're even referring to. These pictures that I see were taken on private property, which would be a Fourth Amendment violation that we are to be held in, that they can't enter our property and take it. That's even a code in the Florida statute as well. I've got so many photos and stuff. I believe it was the town that did it. He stated that he had talked to somebody. Who was it? Who made that allegation?
I'm going off the pictures.
Okay.
Right now, I'm just going off the pictures and the emails.
So the pictures was that earlier, and we had talked about it, earlier in the season, there was a tropical storm that took out a portion of that, which if you look at it, probably less than 25%, which is what he would say would be considered irreparable, irreplaceable. So it doesn't even meet the standard by which he even said it in the first place. There was a beach raking service doing my neighbor's property, and I believe he either went around it and nicked it, or God knows what. Just the other night, we had 3 vehicles driving on the beach that drove up and down my property and into the dunes. I have it on video. I filmed it, and I have witnesses to show it too. There's a lot that goes on that beach, and for them just to say, oh, it's in front of your property, therefore you did it, is a stretch. I mean, it's just a false allegation as far as I'm concerned.
Did you obtain a permit for a vehicle?
Well, the reason why I did obtain a permit is because I wanted to go out beyond my property line out to the beach area, which again, defined under their ordinance, beach means that area of sand along the Gulf of Mexico that extends landward from the mean low water line to the place where there is a marked change in material or physiographic form, or to the line of permanent vegetation, usually the affected limit of the storm waves, or more commonly known as the high water line. The high water line is a good 150 feet past that alleged nicking, or whatever you want to call it, and there's no dune there. Everything he says is a lie, and it's just a false allegation, and it should be not denied on that basis alone. But again, there was no notice, and this has been fast-tracked in less than 20 days.
All right, I'm ready to show my ruling. The raking, the permit was issued and the vehicle was issued, so that's a non-issue.
That's correct.
Sorry for the repetition of the word. Okay. I hereby find that the violations as stated in the notice of violation did exist, and that even the raking, that a permit has been corrected by virtue of the newly issued permit, and that the vehicle on the beach has been corrected by virtue of the permit they have obtained. Those have been complied with. However, there is an issue in reference to the actual restoration of the destruction of the dunes or the vegetation thereof. As such, I am ordering the property owner to submit the restoration plan within 30 days and complete the restoration within 60 days. Otherwise, face a fine of $250 a day until the violation is corrected. I'm going.
Magistrate, there is no
I'm
removal
already
of the
past
dune.
hearing factual. I'm done hearing evidence.
Based on what facts, ma'am? Based on what facts? There's no facts in this case.
I'm going to go ahead and grant the town's request for the one-time fine of the $1,000.
Of course you are.
As a result of the irreparable harm that has been done to the vegetation and the
Still
dunes.
there, ma'am. You could go out there. I got a picture of it. I took it yesterday.
Sir, I already ruled. Case is done. You want to appeal it? Take it to the town council.
We'll appeal it.
Your Honor, next and last on the list, although it's actually not last, but it's the last one that we're going to hear because the last one is compliant, is property owner is Frederick Payne. The violation is work without permit on a driveway. Case number is case number CE 200284. The code officer presenting this case is Bill Stout.
Officer Stout, how are you?
I'm fine, sir.
You previously been sworn in, correct?
Yes, sir.
And you previously testified that you are employed by the town of Fort Myers Beach as a code compliance officer?
Yes, sir.
In that capacity, you're responsible for enforcing the town's codes?
Yes, sir.
Are you familiar with the property at 819 Lagoon Street that is subject case number CE 200284?
I am.
Please explain to the special magistrate how you are so familiar with this property.
On the streets we patrol on a regular basis, talking to residents as we do and being ambassadors and wondering and checking to see if there's any code violations.
And did you inspect, or during the course of your regular inspections, did you have an occasion to visit this particular piece of property? And if you did, what did you observe?
I went by the property and it's a new home construction, and I saw a rather sizable driveway, and I said, that looks a little large. And it's also, I want to check, see if it has a permit. And I checked with my phone app, and there was no permit applied for the driveway.
In order to come into compliance, and what does all the property owner have to do is apply for an after-the-fact permit?
Yes, sir.
Having an opportunity to speak to the property owner at any point?
Yes, I did. I spoke to him, I believe a couple times. One of them was with an inspector who was doing his home inspector. That was one time.
And what was the substance of those conversations with regard to the code violation?
It was about the permit. The homeowner has started the permit. The concern with the town is the fact that there hasn't been any additional activity on the permit since May.
Has the town given any comments back to the property owner as to the lack of action on the permit application?
Yes, the town building inspector has been in touch, permitting has been in touch with him via email, and I believe also phone conversations.
You having an opportunity to take photographs of the property?
Yes, sir.
Those photographs are they in the package?
Yes, sir.
They accurately and correctly reflect the condition of the property and the date you took the photographs?
Yes, sir.
At the driveway that was put in without a permit?
Yes, sir.
A notice of violation and or notice of hearing?
Yes, I did.
They also in the file?
Yes, sir.
I'd ask for.
Just for clarification, I understand there was no permit when the work was done, but I've heard that the permit was applied for. Was it issued and no work was done, or was it applied for, there's revisions needed and nothing has happened? Which of the two is it?
Several more documents have been requested from the property owner, and it's been a slow response. Like I said, the last activity, it is in your packet, copy of the permit. The last activity on this was May 4th.
I just wanted to make sure that we clarified the record, because you said there was no activity on the permit. It almost sounded like the permit was issued and there had been no final inspection afterwards.
That's correct.
I just want to make sure that we're still in the permitting stage.
Yes, we
Okay.
are.
Let me hear from the property owner. State your name and relationship to the case.
Ed Payne, I'm the owner of the property. 2016, I applied for a permit for a new home and paid $5,200, I believe it was. And I had thought that I got all my permits, including the driveway. But when Bill stopped by and said, "You don't have a permit," I was kind of shocked. Hey, what do you mean I don't have a permit? The driveway was on the drawings that was approved by the county, and anyways, he was real good about it, and I applied for a permit and was working with a bill. Was working with the head inspector, and I think he quit or moved on or something. So I had a lapse of time there where he never called me back and didn't return my emails. I then returned to Wisconsin because the offices here had closed and I really couldn't get anything done. It was pretty bad then, you know. I even wrote emails asking for information but got no response. So I went back to Superior. I actually got COVID-19, was hospitalized, and I'm back now. And I have hired, I finally got the surveyor to go over there, which was one of the requirements I needed for the permit. The surveyor was there. He may have to come back. And I have an agreement with an engineering firm, pay them money. And really, I need those two people to complete this.
Okay.
So I just got back and I'm hot on it.
That's fine. So long as you're working on it, like I've said before, I'm a happy camper. All the town wants is compliance.
And I did talk to Jack.
Okay.
You know, email and calls, so
It sounds like you already have everything that the town needs to issue that permit is already in process.
the permit's in process.
From your end, the revisions, the documents that they needed.
I need the actual drawings from the engineer.
The survey and the engineer, but you've retained your engineer and you've already handled the survey.
Yes, I've hired them both, and so I just need time for them to complete.
Okay. Around how much time do you think they're gonna be needing?
Well, it took him an awful long time to do the survey, and if he has to come back, I relate to the guy, not the guy before me, but the one before. all summer long it took to get, so I would appreciate as much as you could give me so that I don't have to come back, but waste your
Hereby find that the violations as stated in the notice of violation did exist and continue to exist. I'm ordering the property owner to come into compliance through the issuance of the permit within 30 days, otherwise face a fine of $250 a day until the permit is issued or the violation is corrected. I'm surprised they didn't ask the admin fee. 25.
25.
Okay, I'm gonna do you a favor, I'm gonna reduce it just a tad bit to $50 in fees and cost. I gave you 30 days, so long as you get it done within 30 days, there's gonna be no fines. Again, so long as you keep it moving and posted, because if you have to come back to me, my first question is gonna be, what's your excuse and where's your paper trail? All right, thank you. I think that concludes our agenda for today. Great, thank you.